My lord, may I have my lord's leave, my lord, to mention an original side matter. My lord, we recall this is a specially assigned original side matter, which my lord had taken up prior to the vacations. My lord, this was the order passed by my lord, fixing the matter on 27th. Or no, just I want to, my lord, will kindly have a look at this order, my lord. My lord had fixed the matter on 27 June 2025 at 2 p.m. That was declared a holiday on 25th, my lord. Therefore, the matter couldn't be taken up. My lord, I'm mentioning this upon notice, my lord. My learned friend is appearing for the. My lord, only thing, my lord, is I have an interim order in this matter which was due to expire on 30th June 2025. My lord, it has expired. My lord, will kindly constitute a bench of the original side in on any date. My lord, will kindly keep the matter as to be mentioned so that I can pray for extension of my interim order. The last extension of the interim order is also I'm carrying the order. If my lord will kindly have. My lord, we've also taken on a formal application, but my lord, my interim order has expired. My lord. My lord, by that order, the interim order was extended till 30th June 2025. My lord, we kindly take the matter upon whichever date. My lord, kindly keeps that to be mentioned because my interim order, I am the defendant number 2, petitioner in GA2.
Petitioner in GA2.
GA2, yes.
You are for the
Plaintiff.
plaintiff.
My lord, will
Right.
kindly take it up as to be mentioned only so that I can pray for extension of my interim order. Or else, my lord, I am suffering.
Today 2 p.m.
Yes, my lord.
Today 2 p.m.
Yes, my lord. We'll issue another notice, my lord. Formally, defendant number 1 is not here. It's an original, sir. I will also take steps in the department. I'll also intimate
Yes.
my lord's officers, but my lord will kindly. My lord, a supplementary list perhaps will have to be published because it's not there.
The audience side बोलो ना supplementary list हो आज के 2 p.m. Today's 2 p.m. You serve other side.
Yes, ma'am. Yes, ma'am.
Fixed on the 27th, your lordship is fixed.
27th of
27th.
My lord, same by the same order, my lord, all the applications were kept
okay,
on the same day.
27th became holiday.
Yes, it became a holiday, my lord. That's why it was.
The date for that
2 p.m. my lord will be here. We'll be
Then
here at 2
all the matter appear on 27. So listing would be on GA2 and GA3.
all the
My lord, all can.
Application
I am
along with
only
the suit.
seeking. I am only seeking, my lord, extension of my interim order, which has.
Listing করতে বলবেন suit along with all applications. Right. Supplementary original side list বেরোবে. Supplementary list বেরোবে 2 p.m. 2 p.m. suit along with applications connected applications. Yes, call the list.
Lordship, may I be permitted to mention one matter of your lordship's order, contempt of your lordship's order, newly filed contempt. Your lordship,
Today is not the day of mentioning. This is the difficulty.
my lord, may I come back on Monday?
Yes, you
Great.
come on Monday.
Great.
Call the list. Correction.
Your Lordship, I am appearing.
Okay.
Your Lordship, I am appearing on behalf of the petitioner. There is a small correction in the order dated 8th May 2025. Can application.
Can number.
Yes, sir. Yes, my lord. Can 2 of 2019, but it should be 2024. I am paying for the correction, my lordship.
Very good. Please take down. This matter appears for correction. Full stop. Next para. In order dated 8th of May 2025. Interim applications being can number can 2 of 2024 was erroneously mentioned as written as can 2 of 2019. Let the can number be corrected by the department within a fortnight. Next.
Grateful, my lordship.
My lord, kindly allow me to appear virtually if your lordship so permits.
Yes, Mr. Mitra, yes.
This is an amendment application which follows from an order passed at page 58 in the application. This writ petition was filed in the year 2006. Then it was affidavit directions were given. In 2015, the writ petition was dismissed for default. Now, because of, and then we filed the restoration application, which was allowed by His Lordship Justice. But now at page 58, man, page 58.
Yes.
আপনি 429 যে রিপিটিশনটা আছে না ওটা জজ সাহেবকে দিন 429 আইটেম নাম্বার আছে সেইটার উপর 4 এর পেপারটা জজ সাহেবকে দিন তো উনি সেটা বলছেন কারণ সবই একই রকম ম্যাটার সিনিয়র আছে
Lordship, Mr. Mitro is appearing in item number 4. All the matters are more or less similar.
same
If your Lordship kindly takes up the papers of item number 4. I've told my Lord's officers to give your Lordship the papers of item number 4. Then the pages will tell you.
Who is for the state?
Mr. Dey is appearing for the state, madam. I'm led by him, madam. He's engaged in code number 19.
Take note. You take note.
Yes.
Yes.
This is really a very formal application. Page 58 is the restoration order. In course of hearing of the restoration petition, Justice Patnaik was very kind to allow the restoration after considering the subsequent events which came to light during the restoration petition being heard. But you kindly come.
Yes, page 58.
Yes, Lordship kindly comes to page 59.
Yes.
So, sorry, page 50, yes, 59, page 60, page 60. At the very top, page 60. On the contrary, Mr. Chundishar, they learned advocate, government pleader, appearing on behalf of the state respondent, submit that there is no day-to-day explanation of delay. It is contended categorically that the petitioner number 1, Rajkumar Saraugi, is to look after proceeding. Rajkumar Saraugi expired on 14 November 2018 after severe chronic ailment. It is also contended that the petitioners did not have any clue about the ongoing litigation since they were not in familiarity with the petition. Further, it is also contended that when a broker was appointed for selling the property through him, the petitioner came across a proposal of the state government to set up a commercial complex bus terminal at Dag so-and-so on public-private partnership, for which an expression of interest had been published on 9th August by the West Bengal HITCO. It was only after December 23 that the applicants started searching and came to learn of the dismissal order. Now, Lordship, the next page, the delay was condoned by His Lordship and the writ petition restored. Now, Bala, the present application is just to bring on record by way of amendment the subsequent events which happened after the filing of the writ petition. Actually, page 86 is the proposed amendment. Page 86 onwards. Paragraph 33 small a, page 86. Page 86, my lord. Page 86. Paragraph 33 small a. 86 to 89 are records. How it was dismissed and it was restored. 86 to 89. These are matters of record.
Yes.
And then kindly come to page 89, 33F onwards. This is to record the subsequent developments. Paragraph 33 small f.
Yes.
In the meantime, further developments have taken place which would corroborate the cause of action of the present writ petition, the illegal invocation of Section 17 of the LA Act, as also illegal issuance of notices under 4 and 6. Out of the lands comprised in 4 separate LR dark numbers, so and so, which form such matter, this one have only put to use dark number 4460. Now subsequent events. So dark number 4463, record of rights have been modified to reflect the same as the government land. A copy. 33I, the present writ petition concerns a plot of land forming the subject matter of the petitioners. Conveys the 7085 dated 27th August, giving serial numbers so and so
Petro,
in the chart.
33A,
It is stated that this
33,
33A to 33E are matters of record. That is from pages 86 to 89. These are the dismissal and the restoration up to
Okay.
33E. 33F onwards are the subsequent developments.
yes, got it.
33F onwards. So this is to really bring on record these subsequent developments.
So what is the relief prayed in this writ petition?
Writ petition original relief, Lordship, kindly come to the prayers. Kindly come to page 98. So, it is for quashing the land acquisition proceeding under sections 4 and 17. That is immediate taking of possession without prior notice.
Okay, okay. Emergency.
Now we have emergency. Now emergency taking possession, but even till today the land is lying fallow.
27
Even till today, 2006 they took possession, and even the record of my possession is still with me. Actually, they are supposed to have taken possession, but actually I'm still in possession. Record of rights is still in my name. Ashif, what I have, and now they are showing there's an award. Award, no payment made to me. So the only prayer at page 99, prayers D, E, F. Really, I'm challenging the award, which came to light only in the opposition to the writ petition, to the restoration application. In the opposition to the restoration application, they produced the award.
So you want to challenge this?
This subsequent development.
Want to
This
amend.
prayer the end. This is
तो message करना पड़ेगा कि it's looking at.
Okay, I understand. So, is there any
So that
evidence
is-
of opposition by the state?
yes, opposition has been filed. It's a formal affidavit. They have not taken in. They've just formally denied.
Only denied.
Only denied, nothing. They have not filed. They have not yet filed their affidavit in opposition to the main writ petition. That's very important. To the main writ petition, no opposition has yet filed. So they will anyways file the opposition to the main writ petition. So they might as well include the amendments and deal with the amendments also.
My lord, in short, my lord, one thing, my lord, to disturb. In short, my lord, I took the point
that requiring body must be.
My lord, may I,
But the-
one,
my lord,
one
entire-
interjection?
my lord,
May I take leave?
my
May
lord,
I take kind leave? I have to, I have another, another
Yes,
four. May I,
Yes, yes,
I'm-
yes.
I'm
Okay,
grateful to man.
Okay, okay.
only for that reason, my lord, that I pray, my lord, that the requiring body must be a party of the proceeding. He can, if he can.
Who is
make
the
a party
requiring
of that-
body?
That has
Yes,
been
my lord.
done.
That is
In
on-
the
that is
amendment
my-
application, that has-
But entire petition, my lord, is amended.
No.
Ah.
The
My lord, if that is so, they can file a short, my lord, application. But if entire amendment, my lord, without, my lord.
They want
entire
to bring
petition-
on record some subsequent events.
Yes, my lord.
This is
Disclosed
their
by the-
submission.
Yes, my lord. Entire petition, my lord, is, my lord, amended.
Enter the nature of the
Entire-
writ petition, whether changed or not.
My lord, I may not
Your-
want to
your-
go into
your-
that, my,
No,
only
they
that, only
challenge.
for that reason, my lord, my lord, we have done affidavit in opposition and other things, my lord.
No,
that-
in the
Second-
read, the notice under section 4 has been challenged. Subsequently, you have proceeded.
He can challenge all the things, my
Yes,
lord.
yes, they can challenge.
I may not.
But in the same proceeding, the
My lord,
state has proceeded further.
on the first occasion, my lord, I took that point that
Requiring
was
body is
requiring
required to
must be party.
Yes.
My lord, he can take that point and take leave or anything else, my lord, to correct that. In spite of that, my lord, entire petition is, my lord, amended.
Okay.
My lord, I may not want 4, 6. That is, my lord, the on merit. That is a 4, 6 and other things. I want to, my lord.
Okay, okay.
Yes, my lord.
understand,
I may not want that. So, my lord, তোমরা কি চাও এখন সত্যি কথা কি বলো তো
আমি সত্যি কথা চাইছি স্যার অ্যামেন্ডমেন্ট করে আপনি অপোজিশন দিন ডিটেইল
এতে কি আছে my lord, your lordship can pass down.
yes
My lord, I may not want that entire, but this
this is good enough for my learned senior friend kindly
No, no,
allows the amendment
না না
So-
সেটা নিয়ে আমার কোনো ব্যাপার না আমার তো তোমাকে কি বললাম তুমি যদি ওইটুকুন করে দিতে আজকে এত বড় পিটিশন আমাদের কত কষ্ট হলো আমার গিয়ে লিখে দিতাম so my lord, your lordship, only for that reason my prayer, my lord, that requiring body must be a party of the process.
But in any event my lord the law is well settled now
My lord,
merits of amendment cannot be gone into. Your lordship will kindly
my lord, I
be
may not want
pleased
go
to
into
allow the
that.
amendment
My
and
lord,
let my learned
he
friend
must
file a
file a give me a
composite
copy of the amended
affidavit
copy,
to the writ petition.
and I must file the affidavit in opposition.
Yes,
other
yes.
things.
My lord, I can. Oh, that goes without saying, my lord.
মাঝখান থেকে একটা আবার একটা affidavit in opposition.
Whether requiring body made party.
Yes, this time it has been made a party. It go. Kindly see, my lord, the cause title once.
Page
76 of your lordship's brief, my lord. My brief is a little different, but my lord, I can assist your lordship. Kindly, my lord, come, my lord, to the last respondent who has been allowed. Respondent number 3, West Bengal Housing Infrastructure Development Corporation, IDCO. This is what my learned friend was, my lord, harping upon. Now it has been made a party. Your lordship's brief, it could be, my lord, page 81, respondent number 3.
page 81 of what?
Of your lordship's, my lord, application, the can that your lordship is looking at,
Page 86.
81, my lord. 4 to 7, your lordship is looking at. 4 to 9, my lord. Page 81. Not
Yes.
there.
Respondent
ma'am.
number 3.
3. West Bengal Housing Infrastructure Development Corporation. This has been added in the proposed amended writ petition.
Okay.
Which takes care of my learned friend's point that the authority has not, the correct authority has not been made a party. Now we have made them a party. We have included the subsequent events which they have disclosed. And my lord, your lordship knows, my lord, now the Supreme Court has said that, my lord, merits of the amendment need not be gone into at this stage. But it will be, whether it's maintainable, not maintainable, everything will go at the time of writ petition.
এবারই তো বলে দিলাম
So, my lord, my learned senior friend has also been candid enough. He wants to, my lord,
But in
Not
your
file an
prayer,
affidavit
in the read, in the application,
yes, my lord.
you have not made him party like that.
একটু
In your-
দাঁড়াও, my lord, the process is that, my lord,
শুনতে দাও।
we must say in a
Lord, kindly, my lord,
paragraph, my lord, that portion is to be amended for this.
my lord, in the prayer,
only-
with subject to correction from your lordship, in at least my lord, what we have learned, my lord, that in the prayer portion, my lord, we need not separately ask for addition. Since we have shown in the amended writ petition, proposed amended writ petition, that the respondent number 3 has to be added, my lord, that will go. Well, kindly see the prayers, my lord. Kindly see the main prayer that I am seeking for. Leave be granted to the petitioner to amend the writ petition in the manner more fully indicated in reading in a copy thereof being Annexure X. So whatever is there in page 81, I want to amend the writ petition in those lines. So, my lord, it is automatically, my lord, subject to correction inbuilt in my prayer. That proposed amendment writ petition, since it shows addition of respondent number 3, let the writ petition will be amended to include respondent number 3. But had it been a standalone, my lord, case,
Want to go into the technical point, raise the
there is no
technical point.
technical
Okay, বলছি, my lord. I do not want to go into the technical point, my lord, your lordship.
will allow. That's why, what's my lord?
You must,
Definitely.
and they
Okay,
must
Your
please
lordship's
take down.
conscience has to be clear. my lord.
amended.
Okay, please take down.
Lordship's conscience has to be.
আজ দুটোই হবে এই কোনো কিছুই তো নেই আমাদের কাছেও আসেনি তো দুটোর সময় এটা একটা লিস্ট কর
One last indulgence, but your lordship, my lord, it's the same. The substance will be the same, but once your lordship's order officer takes down your lordship's order, if he can make separate orders, my lord.
Okay, how many
I think 5 matters.
Five matters. Similar matter, my lord.
you are in all the matters
Yes, my lord.
All.
As a senior, all the
I'll
matter.
pass the separate one.
1, 2, yes, my.
Please
All
take
the
down. Can 3 of 2025. This is an application for amendment of writ petition being WP number 23429 W of 2006. Full stop. Learned senior counsel for the petitioner submits that the instant writ petition was dismissed for default. An application for restoration being Can 1 of 2024 was placed. During the course of hearing of the said application before a coordinate bench, the state authority has informed about some subsequent event in their affidavit in opposition. Full stop. The learned coordinate bench has restored the instant writ petition by allowing the application being Can 1 of 2024. Next, learned counsel for the petitioner further submits that the subsequent events is required to place on pleadings for proper determination of the instant writ petition. Accordingly, the petitioner has filed this application, bringing on record some subsequent events, including adding the requiring body to be a party respondent in this matter. It is the contention of the learned counsel for the petitioner that proposed amendment is formal in nature and it shall not change the nature and character of the instant writ petition. So he prayed for necessary order. Mr. Chandicharan De, learned senior counsel appearing on behalf of the state respondent, submits that the nature and character of the entire writ petition would be changed if the amendment is at all allowed. He further submits that the prayer made in the writ petition has automatically gone into another angle. Thus, the instant writ petition, instant application for amendment cannot be allowed. Having heard the learned counsel for the petitioners and the state respondent, it appears that some subsequent facts are required to be incorporated. Subsequent facts petitioner intends to incorporate in the pleadings by way of amendment, by way of adding some pleadings in paragraph 33A to 33S. Full stop. It further appears that the requiring body was made a party respondent number 3. In tune thereof, some grounds were also added, and some prayers. It appears that the instant writ petitioner, it appears that the petitioner has challenged, the petitioner has filed this writ petition for issuing mandamus upon the respondent authority to quash notice under section 4 of Land Acquisition Act 1894, dated 31/2006. Full stop. The events which petitioner intends to incorporate are the subsequent events after issuance of such notice. Thus, for proper determination of this matter, the subsequent events as well as the subsequent events are required to be brought on record. In my view, the proposed amendment shall not change the nature and character of the proposed amendment is formal in nature, and it shall not change the nature and character of the instant writ petition. According to the instant application for amendment being Can 3 of 2025 is considered and allowed. Full stop. Petitioner is directed to amend the cause title, amend the writ petition and file a amended copy
As indicated in prayer.
amended copy of writ petition after you are to
Prayer
reaffirm.
A to E. Prayer A to E of my application, I have prayed for leave, and I have prayed for a direction that the department be directed to carry out the proposed amendments.
No, department shall not carry. You file the amended copy of it.
Yes,
You have to file the amended copy, not the department.
the proposed amendments we have already indicated.
No, you file proposed amendment, re-verify it and reaffirm it and file it.
Yes.
That would be sufficient and serve upon the state
Yes.
respondent.
But if Lordship will kindly grant us prayer A to E of the application.
My lord, every order দিতে পারবে। যে my lord amended petition will be filed by the apartment filed by.
Just
Yes,
for-
it would be affirmed with a particular date.
Yes, my lord.
Yes.
Not this like that.
Yes,
As you have annexed as annexure X.
No. So that is
Not
not a
like that.
procedure.
Oh, okay. No.
Not a procedure.
File an amended copy of writ petition after affirming the same. Within a fortnight.
There are 5 other matters. Lordship will kindly grant us 4 weeks, says that we do not
4 weeks?
default. Yes,
How can it be? There is a specific guideline in the amended in the CPC. You know the provision.
Yes, but what is 617 is there, but there are 4 to
If
5.
if you can do one, then why the other petitioners are not there?
No, they are there, but there are separate writ petitions. So
You have to file 4.
yes,
Five.
5.
Sometime.
It will take some time.
Okay, come on 3 weeks. Okay, within 3 weeks.
Great.
Full stop. The petitioner must serve a copy of the amended writ petition upon the learned counsel appearing on behalf of the state. Let the matter.
My lord, hard copy to the amended respondent. Hard copy to the added respondent.
Added respondent.
Okay. The petitioner is required to serve the copy of amended writ petition upon the added respondent number 3.
Yes,
HIDCO. And file an affidavit of service on the returnable letter.
Yes.
Let the matter appear in the list in the 2nd week of August 2025 under the heading 2 events.
Yes, grateful. My lordship will be disposing of the application can 1,
Can 3,
can 3.
can 3 disposed of.
Grateful.
I mean with the
And my lord, on the returnable date, my lord, the main writ petition will appear in your lordship's list under the heading to be mentioned.
Under the heading to be mentioned, it will appear second week of August. Main writ petition.
Yes, ma'am.
Grateful.
নিন 5টা অর্ডার হবে 5টা অর্ডার একটা পাঠান আমাকে পাঠান বাকি দেখে নিন তারপর 5টা করবেন ঠিক আছে সেকেন্ড উইক অফ অগস্ট একটা পাঠান বাকিগুলো দেখুন
Below, the can numbers are different in the other matters below.
ওকে
In 4 to the can numbers are all there below. That's the only difference.
you give the name of the learned counsel
Yes, below. It is-
and the can numbers.
yes, but can numbers are already there on the
Well, we
petition
will do it. We'll write it in a piece of paper and give it to your lordship's office.
সবকিছু করে দিয়ে দিও তাহলে yes please.
Be grateful.
Call the list.
My lord, I am appearing on behalf of the state respondent, my lord.
So you are appearing.
State respondent, my lord. This PR is, my lord, refunding the bid money, my lord. He has used and, my lord, withdraw the sand, my lord, as per my instruction, my lord.
This what is the writ petition about?
My lord, he has refund the bid money
Okay.
against this,
He is
my
not
lord,
the
sand
sand-
mining.
Okay.
My lord,
Is
he
not the
used.
successful bidder.
Yes, my lord, he submitted, he used and withdraw the sand from this, my lord, mining. He has already, my lord, used this plot. And, my lord, after that, my lord, he filed, my lord, I am not using this plot, so and so, due to, my lord, due to problem of this road, my lord, we have examined. They have, my lord, used this block, my lord, A block, and, my lord, withdraw the sand, and, my lord.
So what is the prayer here?
Yes, prayer is refunding the bid money.
Refunding the bid money
My lord.
after using the land.
Yes, yes, yes. My lord, prayer, my lord, page 11. No, stay.
Sand block A or B?
A.
A was given to the petitioner.
Yes.
Okay, please take down. None appears on behalf of the petitioner. No accommodation is sought for. Learned counsel appearing on behalf of the state submits a brief history. Submits a written brief history of this matter. Let the written brief history of District Land and Land Reforms Officer Purbo Bardhaman, along with the annexures thereof, be taken on record. Full stop. It appears that from the conduct of the petitioner that he is not intending to proceed further with this matter. Concerning the same, the instant writ petition is dismissed for non-prosecution. is dismissed for non-prosecution. Writ petition being number WPA 14816 of 2019 is thus disposed of. Full stop. Interim order, if any, passed by this court during the pendency of this instant writ petition is also vacated. Connected applications, if any, are also disposed of. Next.
This matter, my lord. My lord, the matter is, my lord, very simple, but the procedure, since my lord, it is, my lord, transferred brief, some difficulty was there, my lord. My lord, your lordship, kindly see first the order of Honorable Justice Mantha. The matter was, my lord, an earlier advocate mentioned for hearing without serving the copy to the opposite other side, and that is why the petitioner was, my lord, fine, my lord, 7,000. Cost was given, my lord, 7,500, which has been already, my lord, deposited. Kindly, my lord, first, my lord, note this.
Enforcement of order or
Duly deposited the amount for the police station, who have received, my lord, the amount. Thereafter, my lord, the matter came before the Honorable Justice Joy Sen Gupta. He released the matter, my lord, want of determination, because it is not a residuary matter, my lord. Now I am approaching before your lordship.
is it group 1 matter?
My lord, next, my lord,
What is the prayer?
my lord, on land, my lord, on the land, on land of NH, my lord, authority, the petitioner's buffer portion, he has a land. In front of that, unauthorized construction, my lord, erected by the respondent number 8.
Respondent number 8.
8. Your lordship, kindly see page 21, annexure 4. NH authority, my lord, inspected the matter and found that the unauthorized construction was there, and my lord, directed the Kulpi police station to take appropriate steps. That steps were not, my lord, taken up till now, my lord. And in the meantime, the petitioner bifurcated one approach land, which was not, my lord, taken permission from the NH, and that is why, my lord, he is not, my lord, using this approach, and can't, my lord, enter into his, my lord, land unless the unauthorized construction is, my lord, demolished. A similar matter, my lord, I have found one order by the Honorable Division Bench, Honorable Chief Justice, my lord.
No, just
Similar
wait.
matter, my
Whether you have served.
My lord, it has already been served, I think, my lord, because learned advocate, previous advocate, my lord, was dealing this matter, my lord. Lordship, kindly see whether it is in record or not.
No, nothing is there.
Unless it is served, my lord, the matter could not be taken up. Service was not done, my lord.
No, order is not there to serve.
I have no knowledge in respect. I can only transfer this, my lord. And learned advocate did not communicate anything to my client, my lord. That is why he changed, my lord, the lawyer. If my lord it is not served, then my lord we have to serve again, my lord. No affidavit of service is there, my lord.
One affidavit is placed on record. It was affirmed on 7th of March 2022. But the order of Justice
No.
Mantha is 20th March. After that,
Thereafter,
Justice Mantha was not satisfied with the service.
no. The service was, my lord, I think was done. But before mentioning for early hearing, my lord, again, generally, my lord, we have to, my lord, serve give the notice to the other side. That notice was, I think, my lord, was not given. He mentioned the matter and matter came up.
Very good, very good, very good. I'm passing the order. You serve again. Please take down. In pursuance to the direction of a coordinate bench of this court on March 20, 2023, the petitioner has deposited
7,500.
petitioner had paid the cost, amounting to rupees 7,500 to the Kulpi police station. Full stop. Receipt, original receipt.
Original, no, my lord. This is Xerox copy of
this color Xerox.
Color Xerox.
Okay. The copy of the receipt, copy of receipt of such payment filed by the petitioner be taken on record. Full stop. It appears that this matter is appearing since 2022. None appears on behalf of the respondents. Accordingly, petitioner is directed to serve upon the respondents and file an affidavit of service on the returnable date. Let the matter returnable in 12th of August 2025 under the same heading.
Deeply obliged.
In this matter, I am appearing on behalf of the petitioner.
Yes.
I am paying not today. Mr. Saurabh Chatterjee appearing in this matter, but he has not come to court due to his uncle's death on the last night.
Very good. Not this week.
Grateful.
I'm for the petitioner, my lord. I'm paying not today, my lord. Since my lord today, my lord, I am without brief, my lord. Since my lord, my clerk, my lord, missed the list, my lord.
Not this week.
Yes.
Yes. Next.
Even my lord, I am appearing for the petitioner, my lord. I am only praying for 2 days accommodation, my lord.
Not this week. तो नहीं none appears on behalf of the parties, let the matter go out of the list. Parties are liberty to mention. Let the none of the parties appears. Let the matter go out of the list. Parties are at liberty to mention.
My lord, I am praying not this week on behalf of the state respondents, my lord.
Okay, not this week.
My lord.
Voting is not this week. Next.
Lordship, I am for the private respondent. That also they have taken accommodation.
On behalf of the state respondents, I am praying for not this.
Not this week. Where is the petitioner? Why the state is seeking? Yes.
Praying for prayed accommodation, Lordship.
Who? You?
Petitioner
You are for the private respondent.
for a private.
Where is the petitioner? Why these matters are running in the list under the heading motion since 2022? That is not requirement for pending these matters in the motion stage. Yes, for the state, what is your submission? Petitioner is not there. Very well, not this week. Next.
16, I am for the petition.
Lord, this is a my lord, ready for hearing matter, my lord. The pleadings are completed, my lord. I am read by Mr. My lord.
No affidavit has been used.
My lord, we have filed a report, my lord. They have filed their exception, my lord.
Yes, exception is there.
Yes, I filed the report. Reply. Sure. The exception has been
My
filed.
lord, I am
Report
read
is
by
there.
Mr. Abhitosh Majumdar, my lord.
Yes.
He is not there today, my lord. So if your lordship may kindly, my lord.
You are appearing for the private respondent?
No, my lord, for HIDCO, my lord.
For HIDCO.
This is a
Respondent numbers
simple
3 and
prayer
4,
for
my lord.
demarcation of the land. Land
The demarcation has already been carried out.
I do not.
I am kindly praying for fixing up a date for hearing of the matter.
Why? That will be disposed of. The simple direction should be given.
My lord, my report will show
the-
that the
how the
demarcation has
landlord
already
afraid
been
of?
carried out, my lord.
The demarcation is prayer for
The
the how the
petitioner cannot
landlord
enter
is
in
afraid of.
multiplicity of proceedings, my lord.
Yes. On last occasion, submission made there on my behalf. If it is the demarcation has been made, how the landlord is afraid of this? I am putting this cost of this demarcation since the portion of the land has been acquired. And now they have tried to enclose the property, my Rayati property. This is the facts.
No, what is the issue here? Why you
Issue here, my lord, my land, portion of the land, enter plot is the 138, my lord. Some portion are already acquired by for the purpose of construction of the road. Now they have started the construction encroaching my property. That's requires for a demarcation of the land. I prayed for demarcation of the land. How the landed friend, my lord, afraid of this? If it is demarcation is made on my cost also, I undertake to pay the cost. As because demarcation is required for the purpose They have started the construction over the Rayati plot of the land, which is not acquired. This is a simple prayer only. And my learned friends submitting that the demarcation has been made. My lord, I annexed the documents, page 66, which has been demarcation has been held on the other cases, my lord, on behalf their land has been demarcated. In the same plot, the plot is plot is a very big plot. I could understand entire plot has been demarcated. Has
Lord,
nothing
kindly
been done.
allow Mr. Majumdar to place the case, my lord.
That is another thing. How the place before the hearing for the hearing matter. This is the motion stage.
Already pleadings has completed. So it has to be heard all together along with the pleadings. So let's next week.
Then lordship, if it is a fixed matter, I am.
Yes, I am fixing the matter for hearing.
Yes, I have no objection if you lordship taken the hearing matter. If you lordship fix the matter, either hearing or forwarders, whatever may be.
Give me the diary. July 11. July 11. কোনো fixed matter আছে? Fix করো তো। July 11, Thursday. No, Friday. Friday. কোনো fixed matter নেই।
ঠিক আছে, ফিক্সড করে হিয়ারিং হোক, আমার কোনো আপত্তি নেই।
12:30. এই মেরা 12:30. WPO 11883. Next Friday. Next Friday, 11th of July 2025 at 12:30.
Yes.
Okay. Okay. Please take down.
Under forwarders, my lord, or
Not orders for hearing. I will pass the order if the hearing conclude then.
yes.
Learned counsel appearing on behalf of the respondent submits that though the matter is appearing under the heading of motion, but the pleadings has already been completed. So we prayed for necessary direction so that the matter can be fixed in a particular date for conduction of the hearing of this matter. Having heard the learned counsel for now, full stop for petitioner doesn't raise any objection for fixing the date of hearing. Considering the same, the matter will be fixed peremptorily on 11th of July 2025 at 12:30 as a specially fixed matter. Call next matter.
I'm for the petitioner hearing. This matter relating to long-term mining lease, the auction floated and the petitioner was a successful bidder. And after that, the petitioner was given a long-term mining lease for 5 years. That 5 years was started on 4th December 2017, and it has already been expired on 3rd December 2022. Meanwhile, Lordship knows that the COVID pandemic was started, and Lordship, the government imposed some restriction and lockdown period. That lease period has not been, mining operation has already been completed, was shut down for that particular time. And subsequently, Lordship, the petitioner made an application before the concerned authority that the lockdown period, the imposition, the mining operation which was restricted by the order of the government, and that order kindly be that lockdown period may kindly be excluded from this lease period. That is the only prayer made before the authority concerned. That authority concerned has not considered till date. Now I'm praying that the representation which has already been pending before the concerned authority be considered in accordance with law. Lordship, this is my only prayer.
So 17 lease.
Lease has expired. It was for 5 years, 17 executed, 2022 lease
22 expired.
Now, Lordship, after expiry, this writ petition has been filed as on date, you can direct the authority to, possibly it was taken up, filed when the lease was in existence, but for some reason the matter could not be disposed of. Lordship
Okay.
can direct the additional district magistrate.
Who is the authority?
Additional district magistrate.
Additional district magistrate. Lordship, one thing is that then in the lease deed there is a clause for force majeure. That clause may be
At the time
looked
of
at the consideration,
that
which may be kindly taken into
that will
consideration.
be given after
And
hearing
all
to
the
division.
notifications and government notifications and
Where are
circulars.
the lease? Where is the lease?
Lordship, I'm
Page.
Lordship, the page started from Lordship 27. 27. And the first Lordship was that the letter of intent, the first annexure, page 19, P1. The letter of intent was.
Where is the clause force majeure?
Lordship, I am showing.
General.
Lordship, I am showing the page. Lordship, page 35. The relevant portion of the lease deed I have annexed. Entire lease deed I have not annexed, Lordship. Page 35, there is a force majeure clause. Part 9, general provisions, and 5 is the force majeure clause. Force majeure clause. My prayer was that the COVID pandemic period may be treated as a force majeure clause, and that invoking this clause, my lease stipulated period.
Where is your representation?
Lordship. Representation, Lordship, kindly come to page 64, the P10. Page 64.
Page 64.
On 5th August 2022, it was submitted, whereas my lease was expired on 3rd December. Before expiring my lease date, I made an application for representation.
Please take down.
ঠিক আছে, প্রভাস করলেন। এটা কুড়ি দেবো।
Most probably.
Petitioner was granted tender, granted mining lease for sand in pursuance of e-tender initiated by the concerned department in respect of sand block auction in Moja, Sanchra, SANCHRA, PS Jamalpur within district Purva Bardhaman, on the river bed of Damodar. Full stop. Petitioner being petitioners were declared as highest bidder. Therefore, and lease was executed between the governor of West Bengal with the petitioner for granting the petitioner of mining lease for sand with effect from the date of 4th day of December 2017 for a period of 5 years. Full stop.
Although, Lordship,
the petitioner was conducting the mining as per rules and regulations of the government. Full stop. It is the contention of the petitioner that due to COVID pandemic, the government imposed several restrictions during the lockdown, for which the sand stroke the mining operation was stopped from 16/5/2021 to 36/2021. This is the period.
Lordship,
This is the second
the first wave and
second lockdown.
March 2020 to May 2020.
Lordship, in my representation, it has been specifically stated. Lordship, kindly have look. Lordship, first term was 21st March 20 to 31st May 2020, and second wave was started.
Okay,
Lordship,
okay, I understand.
in my
I understand. The representation is there. Yes. No, stop. Mining corporation has stopped for considerable period. Full stop. In this period, the business of the petitioner could not be conducted. That could not be conducted and would not be conducted. Thus, the petitioner has suffered huge loss. It is the contention of the petitioner, though the the lease was expired in the year 2022. Prior to expiry of the
Lordship, 3rd December, kindly mention, Lordship.
December 2022, lease is going to expire in December 2022. Prior to that, the petitioner approached the authority so that the lease period may be extended further. Full stop. The representation was made to the department on August 5, 2022. The respondent authority did not consider the representation, hence the writ. Full stop. Learned counsel for the petitioner submits that that there is a provision in the clause in the clauses. There is a provisions in the clause 5 of the said lease agreement regarding force majeure. Force MAJEURE within inverted comma. The COVID pandemic is one of the instance of force majeure. So in that respect, the concerned department must consider the representation of the petition. Full stop. Learned counsel appearing on behalf of the
another annexure I want to read. But page 46, which was at Union of India Finance Minister has issued a notifications for regarding the force majeure clause. Not page 46, sir. That notification.
Page 46.
Page 46.
Force majeure clause.
No, this is
a Ministry of Finance.
Yes, regarding COVID, there are certain directions.
In view of this COVID, kindly be taken to consideration at the time of hearing. It may be reflected on there.
Okay. Learned counsel appearing on behalf of the state respondent submits that the petitioner was declared as a highest bidder accordingly, and lease agreement was executed between the state with the petitioner for mining lease for sand. The department has already taken note of the force majeure clause in respect of several other matters. So this matter may be relegated to the concerned authority to decide the issue afresh. Full stop. Considering the fair submission on part of the state respondent, it appears to me that the matter should be relegated to the concerned authority. Who is the authority?
Additional district magistrate.
Concerned additional district magistrate and district land and land defense officer Purva Bardhaman, being respondent number 3. Respondent number 3 to decide the issue. Full stop. Under the above observation, the instant writ petition is disposed of with a direction to the respondent number 3 to dispose of the representation of the petitioner dated August 5, 2022 within bracket annexure P10 of the writ petition by taking note of notification of the Government of India Ministry of Finance dated 30th May 2022 within bracket force majeure clause. Force majeure bracket close. Bracket close. The respondent number 3 shall dispose of the representation within 6 weeks from the date of communication of this order, after giving a reasonable opportunity of being heard to the petitioner. The decision of the authority shall be communicated to the petitioner within 2 weeks thereafter. Full stop. I make it clear that this court has not entered into the merit of this matter. The respondent number 3 shall dispose of the representation according to law without being influenced by any observation of this court. Full stop. Next paragraph. Since affidavit has not been exchanged between the parties, the allegation made in the petition shall be deemed to have been not admitted. Disposed of.
The same is also the identical matter. Let it be called.
Issue is identical, but regarding the mining lease area,
that will be changed, and 18. The facts is identical, but
date of lease
and the moja is maybe different. But representation dated is same. Petition. Purbo Bardwan. That's it. That's it.
Sand block ta change korbe. In respect of sand block Jamalpur, located in plot number 2800 in Mauja, Chal KHANJ, Chalkhanja D. Roman 3 kora ache first page. এই যে আন্ডারলাইন করে দিলাম দেখুন PS জামালপুর ডিস্ট্রিক্ট পূর্ব বর্ধমান এইটা শুধু লিখবেন ওই যে রিভার বেড ফেড করে চুপ করবেন
River bed is also same, not river bed is also same,
দামোদর রিভার বেড
Lordship.
তাহলে এখানে অ্যাড করুন ওভার অ্যান এরিয়া অফ 9.74 acres
area
the river bed of দামোদর ওইটা লিখবেন আর deed of lease was executed on 26th day of April 2018. What is it going to expire 2022 করেছি না ওটা 23 হয় 23
Lordship. Here is the lease was started on 2018 and expired on
23.
April 23.
23
Great.
April 23 করবেন ওটা December 22 ছিল এটা April 23 করবেন date of representation same
Representation. Lordship, the district authority is different. Here is the 4 ADM is
number 4. Authority is same, but serial number 4.
Serial number.
Serial number 4.
Additional district magistrate and district land and land reform officer part 1 পূর্ব বর্ধমান being respondent number 4 হবে ঠিক আছে
Previously was 3 is 4.
Same. Date of representation is same.
Right. But here the affidavit service was not on the affidavit service maybe kept.
Affidavit service নিয়ে নেবেন তো
Affidavit service.
কটা চারটে দিয়েছে না এটা তো শুরু করি
affidavit service affidavit service নিয়ে নিন
Affidavit service. আগেরটাতে affidavit service দেওয়া ছিল ওটা অনেক আগেই তো আছে
ওটা আগে
the same matter. Same matter.
E2 is same, only the date of lease area.
No, here the date of lease something is different. 18 and March 23 expire on March 23, and Moja is Moja is different. Moja Habaspur Jamalpur, Bardovan.
কত নম্বর এক্সপেন্স দেখো তো?
Here the ADM is 4.
আচ্ছা, আমরা পাচ্ছি।
The grant of mining lease for sand in respect of sand block, ওই sand block টা change করবেন। Sand block Jamalpur stroke Havaspur located in plot number 212 in Mouja, Havaspur, PS Jamalpur, district Purbo Bardhaman, over an area of 9.10 acres in the Damodar river bed. এটা হবে আর হচ্ছে date of execution of lease. Day of March 2018.
Lordship.
Going to expire on
18th March
2023.
23.
Okay. Date of representation same.
Same. And here is ADM is also 4.
Authority is
ADM 4.
additional district magistrate, respond number 4. এখানে respond number 4 same authority. হ্যাঁ হ্যাঁ একটা করে পাঠাবে। Disposed of.
Great. এটা তো দেয়া ছিল।
Next.
Next. Next my item is also I am protected. But fact is that so far I have instructed that petition has expired. But family members, nobody has contact with me. That's why I do not take any step.
Let the matter go out of the list.
No,
Okay.
it will be.
Learned counsel appearing on behalf of the petitioner fairly submits that petitioner has already been expired. He has no instruction about the legal layers of the petitioner. So he prayed for necessary order. Having heard the learned counsel for the petitioner, let the matter go out of the list.
Great. Thank you, sir.
What is your liberty to mention?
বলছে ওরা তো ব্যর্থ করে ডেভেলপমেন্ট হ্যাঁ হ্যাঁ আমি আর আছে নাকি
My lord, on behalf of the advocate on record, Shobnath Rayachudhary, on behalf of the petitioner, I am praying not today or not this week, my lord.
Next Thursday it will appear, not this week. Next. Not this week. For the state, my lord. You are for the state?
Yes, ma'am.
Which for the petitioner? My lord.
Sheila Chatterjee.
You have placed the report.
Yes, ma'am. We have filed the report.
Petitioner is supposed to file exception.
Exception filed, my lord.
Exception filed?
Yes, ma'am.
But it isn't placed on record.
They have served us.
What is the matter?
My lord, they are praying for extension of mining lease that has expired on 2021 on the ground of COVID.
Okay. Force majeure.
Yes, my lord.
I have passed several orders on that point.
My lord, that is not permissible as per our report, my lord.
But the finance department has already permitted.
New sand policy, my lord.
Let you consider the representation. Okay.
In the light of the new gazette notification, my lord, 2021 land policy that has been annexed in our.
Whatever may be, the
Yes, my lord.
lease agreement has already stated about force majeure.
The force majeure, my lord, in respect of performance of certain terms of the lease, my lord.
Yes. Riot, civil commotion, strike, आपको tied terms, title होगा, everything is there.
Page.
You are not saying that the COVID is the not force majeure.
No, I am not saying that, my lord. All right, my lord.
But where is the petitioner? I want the petitioner to be here. Otherwise, how can I? Come on next week. Not this week. Call hearing matters.
This long pending matter, my lord, it is pending since 2008, my lord. The original petitioner died and his sons and daughters have been substituted. They have come, my lord. What happened, my lord? Lord, the father of the petitioner, original petitioner, purchased the said land in the year 1959.
1959. 1959.
Yes.
You take the mic, I cannot hear you.
Yes, my lord.
Yes.
1959. Thereafter, my lord, he got.
Yes.
My lord, he got loan and after sanction of building plan, erected two-storied building over the said land. And they are, till now, they are in possession. My lord, in the year 1978, my lord, notice from collector, Alipur, my lord, for appearing to receive compensation amount, but no payment was received by the father of the petitioner. My come, my lord, at please, my lord. Page, my lord, annexure P3, page 27 and 28.
Page
27 and 28.
27 and 28.
Mana P3, annexure P3.
P27, annexure P6.
No, my lord.
Yes.
Page 27, annexure P3.
Page 27 is P6. So you are referring annexure P3.
P3 and P3, my lord. two notices from the collector.
I think my learned friend is referring to page 21 and 2.
No, no.
এটা তো পেজ তো মিলছে না এই যে 27(6) page 20
Written in Bengali?
Yes, my Bengali.
Okay. It is page 21. Whatever, maybe you just mention it.
But fact remains, my lord, the notice was issued, this notice, but no opportunity was given to me. Notice for my recusal accusation was served upon the petitioners, my lord. However, my lord,
yes.
However, my lord, the petitioner applied before the authorities for, my lord, release of the land, since the said land was not utilized. My lord, that is 11 December 1981. Annexure E, my lord.
You applied for?
My lord, I applied for return of the said land because the land was not utilized and the petitioner's family was, my lord, occupying the said house. No.
What is the letter? Letter,
my lord, has not been annexed. So the change brief, my lord. Letter has not, but from the letter of the KMDA, my lord, it will appear that with reference to your application 12th August 1981.
you are mentioning, you are referring which?
My lord, annexure P4 or E, my lord. At page, my lord, 29.
pages are not telling.
Yes, pages are not telling. So you tell me the date of the letter.
11 December
11 December 1981. Issued by executive engineer.
Yes, my lord.
Eastern Calcutta Project Division.
To meet him and
Sudhir Ranjan Vistas.
Yes, my lord.
That is the father of your petitioner.
Yes, ma'am.
Okay.
My lord.
What is the letter? What is the letter?
Letter, my lord, for return of the land, because, my lord, the land was not utilized and they were in possession of the said land, the house, till, my lord, till date also. Today also we are in possession.
You are requested to meet the undersigned.
Yes, ma'am. Thereafter, my lord,
yes,
one letter was issued by the executive officer KMDA, my lord, on July 30, 2007. My lord,
July
30, July 30 to
2007.
Yes.
KMDA.
KMDA, a chief executive officer.
Regarding allotment of alternative plot.
Yes, my lord. Alternative plot in favor of Sudhir Ranjan Vistas, such and such. The competent authority in KMDA has decided to allot a plot of land measuring approximately 4.6 kathas at plot number 4, comprising in RS DAG number 3701 370C P in Moja Kosba number 13 residential purpose only. This allotment is being made in lieu of the land acquired from you for the purpose of stadium commercial complex at Rajdanga, and on the condition that compensation money awarded by the collector South Chowdhury Pargana for the land acquired would be deposited to KMDA by you. The lease for the land would be executed following deposit of compensation money. My lord, fact remains, my lord, no compensation money has yet been received by us. No compensation money. Therefore, question of depositing any amount to KMD does not and cannot arise. Thereupon, my lord, another letter, 2nd August 2007.
Yes.
My lord, it is also written by Chief Engineer, KMD.
Deposit the compensation money.
Yes. They asked me to deposit the compensation amount, but we have not received any amount.
Whether you have informed them that we have not received
Yes,
anything.
we have made representation. I am showing. But thereafter another letter, 2nd August 2007.
Yes.
To the above memo, Joint Secretary KMDA, I am forwarding here the drawing against plot number 4 within sector B, block BC, EKD project measuring such and such, structure for in favor of your perusal and taking further action. This is a letter. They sent a drawing.
Continuation of the I am forwarding the drawing. So the land allotment was made, not made.
My question of allotment, my lord, does not, because my lord, I am holding my land till date. They have not, my lord, taken possession. I am in my dilapidated house for since my lord 2008, my lord. I am there. No question of compensation does not arise because I have not taken any amount from the my lord, collector, government. My lord, this is the letter, my lord. Another letter, my lord, annexure 8, page 35.
Your letter?
No, my lord. It is also letter written by Deputy Secretary, Work Cell, KMDA. Page 35, annexure 8. My land acquired was, my lord, 5 kata, not 4 katas.
You have shown me the letter dated 2nd August 2007.
Yes.
This is the approx 4.06
Yes,
kata.
yes. Then, my lord, another letter, my lord, they have given, my lord. That is, my lord, at page 35, dated, my lord, November 6, 2007. November 6, 2007.
Whose letter?
My lord, letter written by, my lord, the Deputy Secretary, Work Cell, KMDA.
No letter is there in the writ petition.
Yes, my lord.
Thereafter, your representation is in here. After the letter dated 2nd August 2007, there is a drawing.
Yes.
Thereafter, no such letter.
No, but annexure 8, my lord.
No, annexure 7 is the last annexure.
But this is the letter, my lord, written by, what is the content of reading, my lord?
Yes.
Allotment of alternative plot in favor of Sri Sudhir Ranjan Vishwas, Rajdanga such and such. With reference to the office letter, this is to inform that the competent authority has allotted 4.6 katas of at plot 4, RS number such and such, are requested you to deposit compensation money to the KMDA which was awarded by the collector 24th Pargana for the land acquired, but no reply has yet been received from your end. In this connection, you are requested to kindly do needful as proposed within 15 days from the date of issue of the filing, which allotment of plot will be treated as cancelled. This was the letter. Kindly see next time my reply of my that letter, my client written to the authority.
This is your representation?
Yes, it is my letter.
Letter dated
Yes.
21st of November.
Yes, my lord. 21st November 2007.
Yes.
I have written detail.
So what is your prayer in the writ petition?
My lord, kindly come but prayer, my lord. My lord, at page, my lord, 13 of the petition. A writ in the nature of mandamus commanding the respondents and each one of them to cancel, withdraw, and rescind the purported notice dated 6/11/2007.
Which notice? This notice?
My lord, that notice, my lord,
Notice by
proposed to-
KMDA to deposit the amount of compensation.
Yes, proposed to lease out the property to me and on payment of compensation amount. Second, my lord, prayer is also there. Cancel, withdraw, rescind, because purported notice dated. All those notices were, my lord, challenged by me.
Both the notice you have challenged.
Yes.
And
what
you
happened,
also prayed for quashing the impugn proceeding.
Yes, my lord. No proceeding was taken place. No proceeding. I was never, my lord, called in any proceeding, and no compensation was made.
With the state made party here?
Yes, my
Land acquisition collector?
State is party. My lord, state appeared, my lord, on previous occasions. For me to. One interim order was made by my lord by the Honorable Justice Subramanian Mukherjee, my lord, at Lordship Bedenwal, my lord, directing the authorities to produce any document that the compensation amount was made to the owner, my lord. But that was not done till date. No paper has been, my lord, produced before the Honorable Court, showing that payment has been accepted.
Where is the order?
My lord, kindly see my order dated and show you. Huh?
KMDA was directed to produce the document. Whether any sum was deposited in the court.
Yes, yes, ma'am. But no sum has been received, my lord, by my client or his or their father, my lord. My lord, they have tried to, my lord, change the, my lord, status of my client in respect of the said land. My land they have not acquired, they have not utilized. Practically, that is side of that stadium for which the land was acquired. My lord, some local club tried to, my lord, disturb my possession, and I had to come before the Honorable Court. My lord, they have not paid any compensation, not taken possession. My lord, what remains there under the, my lord, section 24(2) of the new act, the entire, my lord, proceeding has been lapsed because I have not received any amount, nor they have taken possession of the property.
Question is whether your land was utilized or not.
Not utilized.
Not utilized.
Not utilized. We are staying there. There are old dilapidated two-story building is there. We cannot develop it till date. But they are, my lord, only pressing me for payment of the, my lord, payment of the said compensation amount which I have received, but I have not received any amount. And they are trying to change my status from ownership to lessee. Is it permissible, my lord? Whenever the land has not been utilized, why they will not return my land with, my lord, rent compensation?
There is a specific averment in order dated 18th of September 2008. check amount, date has already been mentioned there. You see that?
No, that order is not with me.
Okay, you see that my copy.
Here.
Have you received? Have you seen it?
The order to the
দিন তো অনেক
মুখার্জি অর্ডার ছিল
অর্ডারটা দিন তুলসে দেখো
with that. Yes, yes. I've seen.
Yes.
First paragraph is relevant, my lord. For that, my lord, here. My lord, our status is we are the requiring body. Acquisition is done by the concerned department of the state, being the acquiring authority. All the records relating to acquisition remains with the collector. My lord, after this order was passed, my lord, we have requested the concerned collector to furnish us the details of the awardees and the fate of that award. My lord, unfortunately, my lord, I'm so extremely sorry, my lord. I have not copied it from my copy. If your lordship kindly, this bunch of paper, third page, lordship will find. My lord, I shall make sufficient copy and sub my learned friend also. This is, we have got it from the concerned collector. Third page, lordship, the bottom, at the bottom, lordship will find Sudhir Ranjan Vishwas. In the order, my lord has got it.
Page 3.
Perhaps third page. From the first.
Sudhir Ranjan Vishwas.
I'm sorry, my lord, this is marked. Sudhir Ranjan Vishwas is the original writ petitioner.
Yes.
He died and subsequently this present petitioner was substituted. And in the order, my lord has indicated, there our submission is recorded regarding the amount assessed. Plus you will find the figure will match. So this is Sudhir Ranjan Vishwas was the awardee in respect of his land. Since it appears, my lord, the amount was sent to the concerned, my lord, collector for revenue deposit.
Paid to special LA judge.
LA judge. It was my lord, deposited with the court. What the law requires.
Yes.
If someone doesn't come forward to accept the award money, then it is the obligation of the collector to deposit it in the court.
With the LA judge.
So therefrom they can collect. Here now the case my learned friend is seeking to make out in this writ petition, my lord, that is not permissible. If you lordship kindly take up my affidavit in opposition. May I take that bunch? Lordship has seen the figure is the same which was submitted, my lord, on that day. It's an acquisition, my lord. It's an acquisition under Act 2 of 1948. Admittedly, it would appear from the writ petition at page. Lordship kindly take that page. My learned friend is referred to. Once again, my lord. Lordship kindly come to annexure P3. In my copy, it is at page 1. This is regarding the service of notice under section 3.1. That is the requisition notice, requisition order. The requisition order, lordship will find from the next page. Notice was issued under Act 2. It is the requirement of law, my lord, first of all, an order of requisition to be issued under section 3, subsection 1. This is the notice. The rules regarding issuance of that service of that notice.
You are referring page
in my copy. It is page 21, Bengali written.
Yes,
you will find. This is the mode of service, my lord. Lordship will find that it is an accepted জমি ত্যাগের উপর গৃহাধিবাদের সরকার কর্তৃক দখল নেওয়ার জন্য আগামী so. And the notice in the prescribed form which law requires to be given, that is the next page, 3-1 notice.
Yes.
So after this notice is issued, the land will stand requisitioned by the government for acquisition.
In virtue of LA2, Act 2.
Act 2. I'm showing the Lordship, kindly have a look the provision of law. This book contains both the acts.
Yes.
The last portion is Lordship will left hand and
48.
Yes.
Power of acquisition. Yes.
Power of acquisition. So 3 subsection 1.
Yes.
Lordship will not get from your because that book is very rare. No, Act 2 perhaps not there. Separate. Act 2 আছে? The Act 2.
This is Act 1.
Act 1. Act 2 separately.
Act 1. Act 2 to অনন্ত 1948. 1948 টা আনবেন।
1940.
এটা দিন তো।
না আছে না জোসেফ
দুটো দিচ্ছেন না একটা দিন না বড়টা এটা কি দেখি দেখি দেখান হ্যাঁ রাখুন
My lord can see for the time being from my copy.
Yes.
Lordship, kindly take section 3.
Yes.
Section 3(1) says may I read? If the state government is of the opinion that it is necessary so to do for maintaining supplies and services essential to the life of the community or for increasing employment opportunities for the people, for establishing commercial estates and industrial estates in different areas, or for providing proper facilities for transport, and so, my lord, I am not talking, your lordship. Just skipping few lines. In such areas, for purpose connected there with incident, the state government, plus 3 lines, my lord, I am.
Yes.
The state government may, by order in writing, requisition any land and may make such further order as appears to be necessary or expedient in connection with the requisitioning, provided that so and so. This is section 3(1) requires a notice to be an order to be issued in writing, requisitioning the land.
Order of requisition.
Order of requisition. What is at annexure P3? Just now I have shown to your lordship. Form 1, lordship will find the contents at the middle. And where is the governor? By notification so and so published so and so is authorized me to exercise the power conferred under subsection 1 of section 3 so and so. Now next paragraph. Now therefore it exercises the power conferred under subsection 1 of section 3 so and so. I do hereby requisition the land name. Lordship will find the Sudhiranjan Bishas is there. The lordship kindly turns the next page. Lordship will find the plot, specific plot number 3701.
Yes.
Area of land 1.57 was requisition. Milord, the Act 2, since it's an acquisition proceeding initiated under Act 2, after issuance of 3(1), the moment 3(1) is issued, the land got requisitions by the government for acquisition for public. Then the next step is required to be followed by the acquiring authority is section 4. Lordship, kindly come. This is
Section 4, yes.
section 4. What it requires. This is only, my lord, here pausing here for a moment. My lord, I will show from the rules also how it is to be served. Why this Bengali written notice was issued to the petitioner and admittedly he has received. So he was aware of this. And there, my lords, the rules regarding service of 3.1 was duly followed. There can be no question. So, Lordship, kindly come to section 4. Acquisition of land. Where any land has been requisitioned under section 3, the state government may use or deal with such land for any purpose, for any of the purposes referred to in subsection 1 of section 3, as may appear to it to be expedient. Because in 3, my lord has seen, I have skipped few purposes that refers to. Then 1A, Lordship, this is important. The state government may acquire any land requisitioned under section 3. The requisitioned land may be acquired by the state by publishing a notice in the official gazette that any such land is required for a public purpose referred to in subsection 1 of section 3. So after requisition, it is law requires the acquiring authority to publish a notification under section 4.1a in the official gazette. Then, Lordship, kindly come to subsection 2. Where a notice as aforesaid is published in the official gazette, the requisition land shall, on and from the beginning of the day on which the notice is so published, based absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. So the moment there is a notification issued under section 4.1a and published in the gazette, by virtue of section 2, subsection 2 of section 4, the land will get vested in the state, being free from all encumbrances on and from the day that such notice was published. And this, my lord, this position of law, my lord, since beginning is holding the field, and in catena of judgments, this is affirmed. That the moment 4.1a is issued, the land gets vested under subsection 2. So after such vesting, what remains to do is the assessment of compensation, because the landowner must be compensated. Is the power exercised by the state. So 5 onward, Lordship, the process to be followed by the land acquiring authority, and 7 Lordship, 7A Lordship will find their power has been given to publish an award. So only the section 3 notice the landowner is entitled to get personally. 4.1a is a notification which is to be published in the official gazette, not to be served on the landowners or occupiers. So upon publication, because the owner gets informed the moment requisition order is published, so he is to keep watch what the government did. The moment the 4.1a is issued and published in the official gazette, the landowner and occupier may file an objection, which is required to be heard by the collector.
Yes.
That provision, if someone comes, then notice section 5, Lordship will find. Then personal hearing, that provision is there. That person will be given personal hearing. Whoever comes with any objection, section 5 is regarding the hearing of the persons interested in the land. And if upon hearing, this is about the scheme, my lord, I am making this submission. If the collector is satisfied with the objection from any owner or occupier, then the collector has the power to release certain portion on that provision is section 6. And then 7 comes, my lord, for compensation. How the compensation will be assessed. These are the 5 onwards are the procedure to be followed for the purpose of assessment of compensation only.
Yes.
Then lordship, 7 speaks about the process, how the compensation to be assessed. Then it is required to publish an award, section 7. In section 7. Lordship will find section 7 that how it is to be made, 1. And 2, Lordship will find when compensation has been determined under subsection 1, the collector shall make an award in accordance with the principle. The principle is, my lord, under the proviso of subsection 1. It is laid down the what procedure should be followed. My lord has seen. Now another portion is very relevant, my lord. This is the law. Lordship, kindly after the second proviso of subsection 2, Lordship will find AA.
Section 7.
7 AA, double A.
AA, yes.
Yes. So if, my lord, 7.1 says how to be assessed, section 2, subsection 2 requires the collector to publish an award, and then the consequence of publishing the award. Such award shall be filed in the collector's office and shall accept, as hereinafter provided, be final and conclusive evidence. Once the award is made, this becomes final and conclusive, as between the collector and the person interested. Whether they have respectively appeared before the collector or not. If after publication of section 4.1a, if someone doesn't come, collector makes an award, so it would become final. That is why it is said whether that person appeared before the collector or not, of the true area or value and the apportionment of so and so. So once, if someone is aggrieved by the award, provision is made in the Act, my lord, section 8. If he is dissatisfied with the quantum of award, then he has a right under the Act to make a reference, to apply for a reference.
So what would be there if any person doesn't
my lord,
appear to accept
yes,
the award?
Now kindly, this is the law which was required to be followed. Lordship, now Lordship kindly takes up my opposition. Here admittedly the petitioner has received the 3.1 notice. Requisition notice, it is admittedly the petitioner was in receipt of that. Lordship, kindly come to page 3 of my opposition. This plot was acquired in 2 phases.
Page 3.
Page 3 of my opposition. B.
Yes.
B. 4B. It is 4B.
Yes.
Milord, here I have stated. Milord, this entire plot, Milord, comprises, Milord, 1.57 acres, total land in that plot. This 1.7 acres of land, Milord, is fully acquired in 2 phases. One in the year 1977-78 in a proceeding, and another in 91-92. So, by 2 phases, the entire land in tag number 3701 was acquired. Now, Lordship, kindly come see the first phase. Milord, out of 1.957 in a proceeding, 1.337 acres was acquired in 1977-78, 78 for public purpose. Here, Lordship, kindly come to the middle of this notification being number 8384. My Lord got it at the middle of that paragraph.
Yes.
Dated 1st December 1983 under section 41A of the West Bengal Land Requisition Acquisition 1948 Act. This is this act was issued. So it was issued and published on December 8, 1983. So, in view of subsection 2 of section 4, the land stood vested on and from the date of publication of that notice. Here, Milord, under Act 2, the possession under Act 2 and Act 1 is different. My Lord knows that under Act 1, possession is taken under section 16.
Yes.
After complying with all other provisions, hearing of the landowners and occupiers and all this, then, my Lord, the award, after making award, then possession is taken. But under section, under Act 2, possession is taken before.
Prior to award.
Prior to award with the acquisition, a requisition. Upon requisition, possession is taken. Here, requisition was made, as would be evident from the notice itself, my Lord, in 1978, in February 1978, 8th February 1978. And possession was, my Lord, taken over by the concerned collector and made over to the requiring body on 17 September 1979.
Yes.
Here 2 dates Lordship will find, because possession was given partly on 17th September and partly on 12th January 1979. This is regarding, my Lord, 1.337 acres out of 1.57 acres. Thereafter also, after complying with all formalities, passing of awards and all this, the land was conveyed to, my Lord knows, the requiring body. Though requiring body pays the cost of acquisition, the superior landlord, being the government, requests to be convey the right title and interest in favor of the requiring authority. So that deed of conveyance, the land was conveyed to the requiring authority. That I have stated, referred to the deed. I have annexed also. And my Lord, I shall take your Lordship to the notification. Let me read the next paragraph. This is, my Lord, out of 1.5713 regarding 1.337 acres. The remaining land, that is 0.223 acres, remained after acquisition of the first phase, in the first phase, that was acquired in connection with another LA case, LA proceeding under the same Act, Act 2, in the year 1991-92.
Yes.
And here also, my lord, 41A notice lordship will find from that paragraph I have stated, notification number 4076 was issued, duly published, my lord, on September 11, 1995. So 41 here also, in the second phase also, 41A notice was published. And possession was taken on 31st March 1994. Prior to issuance, of course, that was with the requisition, possession is taken. Possession was also taken. Thereafter, this portion of the land was also conveyed by the state in favor of the KMD, being the requiring body. My lord, in this manner, the entire land in DAG number 3701 was acquired. So nothing left. The consequence of issuance of section 41A, I have shown to your lordship that upon issuance of section 41A, by dint of subsection 2, the land got vested on and from that publication of that notification. Now the question is whether after publication of that 41 notice, subsequent process was followed by or not. My lord, it appears, the bunch I have just now shown, that award was already made. Award was duly made within time. So there can be no question about publication of award to show that there was any lapse on the part of the acquiring authority in acquiring the land in question. So land was duly acquired under Act 2 of 1948. And my lord is searching anything.
I'm searching the notice. The notice the petitioner has shown, that is
I'm coming. I mean,
LA2. LA22.
LA22.
Yes.
LA22 means, Roman 2 means the Act 2.
And the Act 2.
Act 2.
Act 2, and the LA case number is 2. That is in respect of 1.337.
1.337 LA case of
first page.
1978.
First page.
78 first phase.
And second page is LA case number 24.
LA case number
24.
24 of 1991-92.
91-92.
So he appears to be, to come under the first phase.
Yes.
His portion comes under the first phase. So this is the law, and lordship kindly one paragraph, page 10 of my opposition. I have read about the date of possession and notification. I have not shown the documents.
Yes.
This is in the first phase, 1.337 acquired. Possession was taken, my lord, handed over to on 11 September 1977. My lord has got at the bottom the date.
Yes.
The next page, my lord, typed copy I have given. Lordship will find whether in my lord's copy is legible or not.
I have also a typed copy, no issue. Proceed.
No, page 12, the schedule.
Schedule.
Schedule is mentioned. The quantum of land is mentioned. 3701 P, that is part. Here, my lord, in lordship will find the areas, occurs in area 0.82, which if converted, my lord, comes to 1.33. So possession, this is the possession certificate issued by the concerned collector. Because possession is taken by the collector and made over to the requiring body. Then, my lord, another possession certificate lordship will find at page 13. This is with regard to the rest part. Because I have shown two dates, my lord, that 1.33 was given to us on two different dates. One is on 11th September and another one is 12th January 1979. So this certificate I have annexed. So regarding this possession of 1.33, these are the possession certificate which was issued. Now at page 17, lordship will find the first notification regarding 1.33 acres. Lordship kindly page 18. It starts from page 17. Lordship will find the number of that notification. And at the middle, lordship will find that this notice is issued under section 41A at the left hand side column. Now, lordship, at page 18, left hand side, my lord, lordship will find at the end 3701. My lord, got it?
Page 18.
Page 18. Just above the notice, is written.
Yes.
Lordship will find 3701.
Yes.
Quantum is 1.337. My lord, got it?
Yes.
So this is with regard to the first phase of acquisition. This is the 41A notification, which was published. Lordship at the top, lordship will find the date, publication date is 8 December at page 17. The publication date is mentioned there. So this is with regard to the first phase of acquisition. And page 21, what I submitted, my lord, and stated in my affidavit, that the land, along with some other lands, my lord, this plot of land was also conveyed by the state in favor of the KMD. This is the deed I have annexed. And next, lordship kindly come to
certificate of possession.
Certificate of possession in the second phase of acquisition. At the bottom, lordship will find the date when the possession was taken over, 31st March 1994. I have given the type copy also.
Yes.
This is with regard to the remaining portion, that is 0.23 acres. And then page 27, section 41A notification was published. It was published on September 11, 1995. Here, lordship will find in the description of the land, 3701 at the top. The quantum of land is 0.233 acres.
Yes.
So this is the section 41 notification, and then section page 28, lordship will find the concerned deed by which the state conveyed the remaining portion of that land also by executing a deed of conveyance. It starts from page 28. If your lordship turns to page 30, lordship will find the plot number and quantum. The last line.
Yes.
Lordship will find that R is that number in part 3701 within bracket 0.233 acres. My lord, got it? So this is how the acquisition of entire plot was done. And under whether under the Act 1 or Act 2, there is no provision either in the Act 2 or in the Act 1 to return the land or to provide land in lieu of acquisition.
Unless the release order has been passed.
Unless the release order has been passed. There is no provision. And once the moment 4-1 is issued, the land gets vested in the state. State becomes the owner of the land. And in the instant case, what I shown to your lordship, I shall make I can make a copy, because these documents we have got it from the land acquisition department. We could not annex it
to file a copy.
Yes, I can. Here it shows from records, it appears from record that award was duly passed, and Sudhiranjan Bishas was figured, name of the Sudhiranjan Bishas figured as
awardee.
award. And the money has been sent to the
LA court.
LA court. So there is nothing irregularity or illegality in conducting the LA proceeding, and by virtue of this acquisition, the land gets vested in the state. Subsequently, on transfer, the KMDA became the owner. Now, question few letters which my learned friend has relied on in this writ petition, my lord, regarding allotment of alternative land. This is with regard to the few letters my learned friend has referred. Because here, one letter he has shown that he prayed before the KMDA authority for release of the land. KMDA is nobody to release the land. And requiring body doesn't have any authority. It is the acquiring authority who can do.
Or the collector, who is the
collector. And the another letter which is about alternative land of a plot of land. Here, my lord, perhaps that was not proceeded with and could not be proceeded. There is no law under the law. The owners of the respective land which is acquired can get compensation. That much is provided under the Act. Act doesn't provide for any alternative plot of land in lieu of that compensation. And here the promise, the letter which was issued, appears to be issued by the KMDA authority to provide alternative plot of land, that is altogether different from the land acquisition aspect. Here, what happened when we had constructed, doesn't come within that. My lord, few structure had to be demolished. Although the Act doesn't provide for providing alternative land, at that point of time, that was not a policy taken by the authority, but it was because there was several representation made to the authority that few structures were demolished for execution of the project we have undertaken. Then, my lord, at that point of time, that is long before, a decision was taken that whose structure existed prior to 1978 and wholly demolished in execution of the providing a plot of land. This is not the case of the writ petitioner. And here, for that, my lord, we had decided that the compensation money which was awarded in respect of the land which the person is claiming, that had to be deposited first. my lord, to become eligible to get. That is what, my lord, the petitioner, the Sudhir Ranjan Bishwas, that is the original writ petitioner, this letter was issued to him. Deposit the money. It is not the requiring authority who is to make assessment of the compensation, who is to pay. It is the completely task of the acquiring authority to assess compensation.
Where is such geo that you will provide a land to a landlords and you will accept the compensation
There
money?
is no such policy. That is what I have.
Where is the policy? Why you serve the letter like that?
This correspondences, why this issue, and this does not, my lord, in my respectful submission, my lord, when the law doesn't provide for by the executive authority by writing such a communication cannot confer any right on the individual.
However, maybe you have offered him to give some plot, but you are trying to extract some money from him. How can you extract money like that?
No,
there is no such authority.
No, this is no.
There must have some guideline or rule or notification to that effect.
Now here this letter.
Why the KMD asking the compensation money from a landlords?
Here that letter says that the money to be on condition that the compensation money awarded by the collector for the land acquired would be deposited to KMD by him.
Why the compensation money? Why not the separate money or the money per katha like that? Why the compensation money, particular compensation money? What is the right there to have the compensation money?
My lord, to that extent, to my knowledge, my lord, there is no such policy.
There is no such policy, I think.
There is no such policy.
You can fix some rate to the per katha.
We can, if we have the land, we can sell it.
You can sell it or you can offer it on humanitarian ground. You are landlords, you can come.
That we can do.
That too also on such policy, on some policy, not like that.
That must be
yes, there must have some policy to that effect.
My lord, to my knowledge, my lord, this how this communication was issued, and this in effect, my lord, doesn't create any right, because the land was what my effort was to show your lordship. The land was acquired duly.
Primarily, they challenge your notices, 2 notices.
If 2 notices, my lord, are gone, yes, these notices cannot stand. Another prayer he has made for quashing of
challenge the quashing of LA process.
So no pleading, no grounds has been mentioned. So I am on his second prayer regarding the acquisition. Challenge to the acquisition proceeding doesn't stand. Even if my letter goes, what benefit the petitioner will get? He can, now it appears from the record that the Sudhir Ranjan Bishwas was in a word. And assessment compensation was assessed in his name. That is lying deposited with the LA court. He can apply, he can very well apply there and collect that money. And the land once vested, my lord knows that is the settled position of law until the constitution bench division, constitution bench judgment also. The land once vested, it can't be divested. So land got vested with the publication of 41A, and the subsequent procedure was duly followed by publishing.
Okay, I understand. Yes.
There can be no challenge to the acquisition proceeding.
Very good. I understand. So, what is your reply?
My first question is that, the authority.
You take the mic, I cannot hear it out.
Authority, my lord, acquired the land. I admit that acquired the land. But why? They have not taken possession of my house property till date. From the date of acquisition now, we are staying there. ever they took step for disposition of my the family. Furthermore, my lord, the possession which he is, my lord, stating, the possession was given by the state to the KMDA, but it is, my lord, formal possession, but not physical possession. I am still now holding that land. And my lord, why? They will return me only 4 cutters, something, 15 shotaks of land, yet they have not given me either by lease or by lord return. I am claiming entire land because that is not utilized. That is lying manner as it is. My house is there, I am staying there. What they will do, my lord, with the said land? It is my land. It is my property. It is hit, my lord, under 300A of the Constitution of India. Because they cannot take my land, it is forcibly they have taken my land. And no proceeding, I was, my lord, present. I will not.
There is a particular proceeding, you cannot say.
But
Section 300, Article 300 is clear. Without due process, the state cannot.
Well, I'm saying that
State has proceeded under LA proceeding.
But they have not.
Your father was already there.
I have not issued any notice, my lord. It is fact, my lord. I have received any compensation.
You received the notice.
My possession has been
Yes,
taken.
understand. You have not received any compensation. That is true.
No,
But your father was already there.
Already there, but
you have not raised any objection before the LA collector regarding releasing of land.
It is, my lord, paper award, my lord. We have no knowledge about it. We do.
You have annexed the notice. You have annexed the notice.
But what amount award was given, we are not known, my lord. But it is absolutely, my lord, illegal, my lord, proceeding they initiated. And my lord, I have been, my lord, because of that, my lord, they have not, my lord, dispossessed me. They have not taken possession of the said land till date. And no award amount has been received by me. According to my lord, entire, my lord, proceeding has been lapsed under section 24(2) of the new act. Entire proceeding has been lapsed.
How? They have already, award has been passed.
Award has passed, but I have not received, I have not been given
You
any
may not
award.
be received, the award is there. You can receive it
Any
from the
amount,
LA
my
court.
lord, any amount I have not received. Any amount. Not that they have, my lord, took
When
possession.
award has been made, whether you receive it or not, that is not the question. Question is award is final.
But my
You
lord,
may challenge it.
but
That
my
is
lord,
your option.
my lord, they are trying
Your
to.
contention is you are in possession now.
Yes, till date.
Till date you are in possession. So this is your question. Okay, very well.
One submission may I add. My learned friend is harping on possession. My lord, this here the law is settled. If your lordship says the underdevelopment authorities how the possession is taken.
Yes.
Here not only his portion of land, a vast area was acquired. There underdevelopment in underdevelopment authorities case regarding this clearly say at paragraph 37, if I correctly remember, how possession is. Here the situation possession is deemed to have been. And then it has been affirmed in the Indo that after acquisition and vesting, if someone remains in possession, he will be treated as mere trespassing. Nothing more. And it is also, my lord, reiterated earlier decision in S. Palani's case. S. Palani's case also said, my lord, that if someone remains in possession of acquired land, that do not create any right in his favor by remaining even for long time. He will be treated as mere
They have,
and Indo development
they have completed the project. That is one Acropolis Mall, another is Gitanjali Stadium. They have completed the project. Only the strip of land of mine, my lord, is lying vacant. And I am staying there. What is the, my lord, use of keeping that land there? Because the land was not necessary for
Very good. Hard.
project.
Please take down. Present petitioners are the legal heirs of original petitioner, now deceased, Sudhir Ranjan Vishwas. Full stop. The brief fact of the instant writ petition is that father of Sudhir Ranjan Vishwas, namely, no. Give me a copy of your document. বললাম বলুন কি বললাম বলুন হুম 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 না ফাদার কাটুন দ্যাট করে বাকিটা কাটুন that Sudhir Ranjan Vishwas is the original owner of plot number plot number 3701 Mauja Kosba, measuring 5 katha, which he purchased with a registered deed number 1185 dated 19 to 1959. 19/2/1959. It is a further contention of the petitioner that for the purpose of construction of residential house, said Sudhir Ranjan Vishwas applied for government loan and the said loan was sanctioned. Building plan was sanctioned. Building plan was sanctioned from Daden Union Board. Sanctioned by Daden Union Board, and the name was mutated in the land reforms record of right. Land reforms record of right. Land reforms record of right. Suddenly, Sudhir Ranjan Vishwas received a notice of requisition being LA case number Roman 2/2 of 1977-78. Full stop. The said notice annexed to it a notice under subsection 3 of section 3 of West Bengal Land within bracket requisition and acquisition bracket close Act 1948. Full stop. It is a contention of the petitioner that he is in possession over the said stretch of land, and his possession was not of the said stretch of land. Full stop. The land was never acquired by the authority, by the requiring authority. In the name of Sudhir Ranjan Vishwas.
KMC. They have paid taxes also.
Okay. তাহলে ওখানে যে করবে রেকর্ড অফ রাইট যেটা বলেছিল আর ল্যান্ড রিফর্মস রেকর্ড অফ রাইট করলাম না, শুধু রেকর্ড অফ রাইট করলাম, এরারটা কেটে দিয়ে রেকর্ড অফ রাইট ওইখানে একটু অ্যাড করুন ছোট্ট করে স্টার দিয়ে। Petitioner is possessing the land by giving tax to the municipal authority, and his name was mutated in the role, in the ROLE role. হয়েছে ROLE role, municipal role আর কি। তাহলে তো হয়ে গেল। কি হবে তাহলে? এসে দেবো, এসে দেবো। হ্যাঁ, ওকে, ঠিক আছে, তাই দিয়ে দিন। কতটা বললাম বলুন, লাস্টে কি বলেছি? নো possession requiring body হয়েছে তো, possession was not taken over by any of the government authority, এটুকু থাকে। অরিজিনাল সাইড, হ্যাঁ কি এখানে চেম্বার পাঠাও, এখানে দিয়ে কি করবো? অরিজিনাল সাইড আছে, অরিজিনাল সাইড তো একটাই ম্যাটার আছে মানে, হ্যাঁ একটাই ম্যাটার আছে, তারপর আমি এটা নেব। আপনি যদি আসেন আসেন, না হলে নো কাউকে বলি। হ্যাঁ ঠিক আছে, ওকে, কন্টিনিউ আফটার 2। I have started dictating the matter. That is the. There must be an order of adverse by one party or another party.
Continue.
Yes, it is continued. Let it be continued. At 2, I will continue the matter.
Will come.
Okay, okay, very good.
With your lordship pleasure to take up other matters, appellate side matters.
If
After
I will be here. If you are Supplementary list. Which? Call for the supplementary list. Here, 2, 3. 4 to the edge. Let me get. Okay. Okay, fine. Supplementary. ঠিক আছে। Done.
I'm appearing in this matter, my lord.
I am for the defendant number 1.
You
It's
appear for the
shocking that
defendant
it has been mentioned without any notice to any of us. No, let me finish. In a specially assigned matter, it was last due to appear on 27th of June. That day, the court was not there because of the Rath Yatra. Thereafter, the interim order expired on 30th, that is last Monday. For 4 days, they were silent. Today, they mentioned without notice to us and get it specially fixed at 2 o'clock. And what they suppressed is, in the meantime, they went to Alipur on the self-same cause of action and have obtained another interim order over there. And there's a vacating
Interim order
application.
is there.
Interim order is there in Alipur. Lordship will have a look. No, it's on the self-same property. No, it's on the self-same property, Mr. Mukherjee.
Kindly hear out the application today, my lord, kindly.
No.
Yes,
You just can't say. No, it's
So my
D2's
learned friend
application.
is-
No, it's
my learned
D2's
friend is
application, not yours.
saying all
Mr.
these
Rai,
things,
it's
my lord.
D2's application, not
It
yours.
was only decided that we'll fix a date, my lord. I don't know how
That is
this
with
coming
regard
up.
to your
So let us
application.
do the
That is
application,
with
my
regard
lord.
to your
I am
application,
also
not.
asking for an interim order, my lord.
Yes.
This party, my lord, has been playing
No.
fraud on court
They
continuously,
also
my
have
lord.
filed a suit
So,
over
my
there.
lord, I want an order. So, my lord, will kindly hear me out.
My lord will fix a date.
Then, my lord, will
Because my
kindly.
vacating application to the vacating of the interim order is also there. That is GA4. That was not
Let that
mentioned.
be heard out.
Yes, my lord will
Everything on
fix
the
the date.
18th, my lord,
My lord
kindly
may fix
take
the
some-
date.
Lord, as one submission, only I am the defendant number 2.
Let him say that he has served notice.
Lord, I am saying, my lord, my application is traveling from 10 to 11. I was under a mistaken impression. And I'm admitting this, there's no dispute. But mistakenly, notice was not sent. The plaintiff was served. It is a mistake on my client's part.
So you have not served the
No.
One second.
And the plaintiff communicates to us that D2 has mentioned matter will appear at 2 o'clock.
Kindly, my lord, will take the email communication.
Yes.
I served notice.
Before that, it came at 12:19 and the
No, mail is not required. During the day when the matter is listed, I supposed to fix a date, not the hearing of this matter.
Yes.
Only that the day, the 27 was the declared holiday. That's why I want to fix a date. That is only intent.
Lordship will fix it on July
I came to
18th.
inform them that the matter shall appear.
That's why we also informed, because our application was also being listed.
Very good, very good.
So,
So,
informing about GA3.
application being GA2 is for
My application for injunction, wherein I was enjoying an interim order, my lord, passed by Honorable Justice Raj Patnaik in July 2024. That has never been challenged.
I filed that vacating. No, I filed a vacating.
Sorry, that vacating
What?
application came in May 2025,
So?
after a year.
So?
Today I am seeking only the limited extension.
No, Your Lordship, because they have already obtained an injunction from Alipur.
GA2 is an injunction application. GA3,
J3 is my learned senior.
vacating application.
GA4 is my application for vacating. GA3 is the application of the plaintiff for appointment of administrator pending delay.
GA3 is also asking for an injunction against the defendant number 1, my lord, because they are dealing with all properties of the testator. But he might go and say, no, that is what your lordship will have to decide, my lord. So there is some urgency in that application also. That's why, my lord, let that be also, my lord, kindly be taken up on the 18th. I'll be asking for interim orders.
So if I hear out the GA2, it would be cover everything.
No. 2 and 3 are different.
Both have to be heard.
2 is with regard to a certain one property at Shodhpur. One second, Mr. Mukherjee, you had your turn. GA2 is with regard to one property at Shodhpur, which is owned by a company, which is not even a party, because it's a testamentary suit. And I have filed a vacating application to GA2, the order which has been
GA2
passed.
is a vacating application.
GA2 is the injunction application. GA4 is the vacating. Filed by defendant number 2. I am 1.
May I just make one
Mr. Rai, one second.
Please.
May
I
request
make a
one.
submission? No, may I?
Oh.
Because I am the plaintiff.
Yes.
They are saying a lot of things, but I don't understand where they are coming from.
Yes.
I am the executor.
Maybe you're not the beneficiary.
Please. I am the executor, my lord.
I have made an application, now it is being contested. No dispute about that. In that, my lord, one of the challenging parties, which is my learned friend's client, has made an application against the other person, who is also challenging the validity of the will.
Okay, I
Now,
understand now
no, my lord,
situation.
only my application, as a matter of fact, which I have taken up is J3. It is for injunction on all the properties of the testator. So there is no division. So therefore, my lord, that is the most comprehensive application. Affidavits are complete.
So what application has to be heard?
But first, J3.
Lordship, all GA2 and 4 needs to be
I think
heard.
all can be heard
All
together.
can be heard together. And GA2 and 4, in GA4, there was a direction for filing opposition, which they have not filed, so it goes unopposed. So let GA2 and GA4 be kept together and GA3 on 18. No, they have not. It's out of time. Oh, everything is out of time.
My lord, I have filed that.
Four
I have
copies,
filed
sir.
an opposition, my lord. He's Mr. Mr. Shorgar is not correct, my lord. I have filed my opposition to GA4.
I am saying, but GA4 is my vacating to GA2. The defendant number 2's application.
I'm supporting there. I want an injunction
Yes,
against you. You are the tainted person.
Yes.
Who's continuously dealing with the testator's property.
Yes.
Very good. I understand. Let all the GA be appeared along with the title suit.
Testamentary suit, yeah.
Testamentary suit. It would be appear. It would be appear on 10th.
Your Lordship, on 18 July, Your Lordship.
18 June.
Oh, 10th August. Oh, 10th August.
18 June ছিল। জুন তো পেরিয়ে গেছে। জুনে তো পেরিয়ে গেছে। ছেড়ে দাও।
এবার তোরা এবার লড়ে নেই ইনজাংশন জন্য লড়।
এনতে কিছু রাখা আছে?
আমি
ছিলাম না বলে কিছু না। Okay. Let all the applications being GA2 of 2024, GA3 of 2025, GA4 of 2025 be appear along with the testamentary suit on 10th of July 2025.
Kindly keep it on 18th July.
18th, my lord, if it could be done.
18th?
18th, Your Lordship.
18th আছে? দেখো।
And today, আমার ইয়ে একটা সব আমার কেন
Well, 10th also, my lord, I'm okay. My lord, if my lord.
Let me see whether 18th I have fixed one parted matter or not.
Or 17th, if Your Lordship pleases.
Huh?
17th হবে না 16th করে দেন।
হ্যাঁ
16th, my lord, if your lordship comes.
তার আগে सुराना है नहीं
आज इसी वक्त
17 सुराना
आज ही हाँ इसी वक्त
17 सुराना फिक्स আছে এটা ও 17 জুন না জুলাই বলছি 17 17th July?
Lordship.
17th of July at 2 p.m.
Leaving aside all issues, the
Hey, man,
I am the son of the district. I had come forward for an application stating the defendant number 1 from alienation and asset of the receipt. An order was passed by Honorable Justice Patnaik, 15 July 2024, subsisting to 30th June 2024, timing limited extension to that. It has
No.
never been challenged. Nobody is
No, I filed an vacating.
vacating application in May 2029.
So,
Only limited.
Your Lordship, that interim order has already been expired. It has expired. And they have obtained an interim order from
One thing I
Alipur.
can only say, my lord, it will protect the assets
No.
of the testator till
No.
your lordship
No.
decides that.
The Lordship will consider it on 17th.
That
Lordship will
means-
consider it on 17th.
Intention is to deal with the property if they're opposing this.
No, what deal? They have already have an injunction. They already have an injunction from Alipur court. Let them deny that it's not on the same property.
Because, my lord, I am
Let
supporting
Mr.
this
Learned
because,
Friend
my lord,
deny
the
that this
executor-
injunction passed by Alipur court, the order of status quo is not with regard to the same property. No.
My lord, these are all properties in the affidavit of asset, my lord.
27 June.
Even the Alipur suit was also the property part of
But
the
kindly
Alipur.
appreciate that all the legal
Same
heirs,
parties, same
persons who are
self-possession.
challenging Malat, they are
Yes,
all
yes,
saying
yes,
that this
Mr.
person
Mukherjee.
is selling. So I am the executor, I have the
But
affidavit
you
of
have not
assets.
filed this
It has
application.
come before your lordship as a contentious cause first to decide whether the will is correct or not. Now, Malat, if your lordship decides the will is correct, Malat, they are going to deal with the property.
No.
And the assets will go. That
Lordship
is
will
my
kindly
injunction,
consider it
Malat.
on 17th.
So I'm supporting this one. Till 17th, your lordship extends it. And then
Lordship, Lordship will see Alipur court has already passed status quo on the
that
same
is of no
property. It cannot be there.
consequence.
There's no, of course.
No, I understand there is an interim order which
Interim
could
order
not
passed
be
by Alipur
extended as the 27th as the holiday. That is the only reason.
Yes, Malat.
We would have prayed for the same.
No.
So Malat keeps it till the next date, Malat, and then your lordship decides.
It was till 30th, your lordship. It expired on 30th. For 4 days,
So
once
that's 27th was
for
the
4
next.
days, they were sleeping. Suddenly, today, without any notice, they mention and keep it at 2 o'clock, serving us that at 12:30, that matter is being fixed at 2 o'clock. This is a complete sharp practice. I'm
There
sorry.
is an apprehension for dealing with this property.
Yes, but
No. Let them show one single document I have dealt with it. No. Let them show one single document I have dealt with.
Orders are there, I understand.
Malat, first they had made an application. Now, Malat, different number. Now I, as the the executor, had to make an application that please now injunct everything because now they are dealing with the properties.
Appeal court has dismissed their application ad interim prayer. They have been refused the ad interim prayer.
Affidavit in opposition against GF4.
Not know
By
Defendant number 2.
affidavit in opposition against GF4 of 2025 by the defendant number 2 be taken on record.
Your lordship may leave be granted to use a reply to the opposition in the meantime.
The
It has been served
defendant
today.
number 1.
By one. Defendant number 1.
Number
It is
one.
my application. GF4 is my application.
Defendant number 1 may use reply to the affidavit within the adjournment.
Lordship.
Very grateful, Malat.
Give.
Thank you.
কত কিছু নিচে কিছু দেখছি আমার তো পাবো আমার কিছু নেই তো
Appellate side.
Deeply.
গ্রেটফুল J3টাও থাকবে J3টাও থাকবে বলেছেন সব থাকবে ভেরি গ্রেটফুল ইনফিমারটাকে সবকিছুর উপর নিয়ে নিলাম
তারপরে এয়ারপোর্ট কাউকে পেন্ডিং কাজ থাকলে এবার কি হবে আসতে হবে না কোর্ট চলছে না না যে পার্টিতে যায় না কি আছে It is the further contention of the petitioner that as his land was not acquired, stroke, possession was not received by any of the authority, he filed an application with the concerned authority for release of his land. On such request, Executive Engineer, East Calcutta Project Division number 1 issued a memo upon the petitioner on 11th of December 1981, asking him to appear on his office on 24th of December 1981. It is the further case of the petitioner that the concerned authority has heard the petitioner and assured that if his land was not taken for the purpose of acquisition, the land would be released. Full stop. The petitioner submits that thereafter by the letter dated 30th July 2007, as well as November 2007, the KMDA authority informed the petitioner that the KMDA has decided to allot a plot of land measuring approximately 4.06 katha at plot number 4, comprising RS Dag number 3701 in Mauja Kosba for residential purposes only. It has been also instructed by the authority, by the KMDA, that such plot of land would be allotted on condition that compensation money awarded by the collector, South 24 Parganas, has to be deposited to KMDA. Petitioner, being aggrieved by the said letter, approached this court and challenged the issuance of such notice by the KMDA. The petitioner also challenged the proceeding, being LA case number Roman 2/2/2 of 1977-78. Learned counsel for the petitioner argued that as the land never possessed by any of the authority, thus the land is required to be released. The proceeding of LA case, which resulted to the acquisition of the said land, has never been acted upon. It is only a documentary acquisition. No possession has been taken over. Thus, the impugned proceeding is being LA case number 2 of 1977-78 is required to be quashed. Learned counsel, appearing on behalf of the Calcutta Metropolitan Development Authority, submits that RS plot number 3701 of Mauja Kosba, District South 24 Parganas, measuring 1.57 acre in total, is fully acquired in 2 phases. First, in the year 1977-78, and secondly, in the year 1991-92. the concerned LA collector, South 24 Parganas, has completed the proceeding completed the acquisition proceeding for the public purpose, that is for East Calcutta Area Development Project. He further submits that in the first page, out of total area of 1.57 acres of land, an area measuring 1.337 acre was acquired by LA case number capital LA Roman 2/2 of 97-98. He submits that for the same purpose, the notice under section 4 within bracket 1A bracket close of West Bengal Land within bracket Requisition and Acquisition Act 1948 was duly published in the official gazette on December 8, 1983, and the possession of the land was handed over to the concerned collector by the concerned collector to the KMD authority on 17/9/1979. Full stop. In the second page, remaining portion of 0.233 acre of RS plot number 3701 in Mauja Kasbah was acquired in connection with LA case being number LA Roman 2/24 of 1991-92 for public purpose. Full stop. Notice under section 4 within bracket 1A of the West Bengal Land Acquisition, West Bengal Land within bracket Requisition and Acquisition bracket close Act 1984 was published in the Calcutta Gazette on September 11, 1995. Full stop. Possession of the said land was handed over by the concerned collector to the KMD authority on 31/3/1994. He further submits that the notice of requisition was initially published. Thereafter, the land was acquired by issuance of notice under section 4 within bracket 1A of the said Act 2 of 1948. Full stop. He submits that after such acquisition, after such issuance of notice under section 4 within bracket 1A of Act 2 1948, the land under such acquisition vested to the state free from all encumbrances. Full stop. He further submits that the concerned collector has already made an award to that award in respect of the said acquired land, and the an award amounting to rupees 3,20,912.32 paisa was deposited in the name of Sudhir Ranjan বিশ্বাস, petitioner, through the special LA judge on 2nd January 2001 by check number 645703 dated 28/11/2000. He submits that the land has been successfully, and the state has successfully acquired the land according to law, and the same was handed over under the possession of KMD. Full stop. The petitioner cannot challenge the entire LA proceeding at this juncture. So he prayed for dismissal of the instandard petition. Having heard the learned counsel for the parties, it appears that the petitioner has challenged two notices issued by the KMDA, wherein they offered the petitioner a plot of land measuring 4.06 katha at plot number 4 in Mauja Kasba, on condition that the compensation money awarded by the collector, South Chobis Pargana, has to be deposited to KMDA. Full stop. On query, it appears that there are no such notification or guideline in the KMDA to ask the petitioner for depositing the money which he received by way of compensation. Moreover, law doesn't permit any authority to ask for the compensation money of a landlooser for the purpose of giving him a freehold land. Full stop. Furthermore, if it appears to the authority that at the time of acquisition, some structure of the plaintiff of the petitioner are required to be demolished, and if it appears to the authority that the said person stroke landlooser are required to be given a plot of land on humanitarian basis, they may offer the same to the landlooser, but not in lieu of payment of compensation money. Thus, the notice impugned dated July 30, 2007 and November 6, 2007, issued by the Kolkata Metropolitan Development Authority, appears to me not on the basis of any notification or authority of law. Thus, the same are hereby set aside and quashed. Instead, the petitioner is at liberty to approach the KMDA for allotment of such land which they offer in lieu of money to be assessed by the concerned authority. At the rate when the land was actually acquired. Full stop. The petitioner is at liberty to file a representation to the authority to that effect. I present to the KMDA, competent officer of KMDA. Being respondent number 5 of this matter, 5 of this writ petition, who shall dispose of the representation within 6 weeks from the date of passing of this order, date of receiving of this order, no, from the date of receiving of this representation, after giving a reasonable opportunity of being heard to the petitioner. Full stop. The respondent number 5 shall dispose of the representation according to the law without being influenced by any observation of this court. Full stop. In respect of the prayer of the petitioner regarding quashing impugned proceeding being LA 2 of 1977-78, it appears that the concerned authority has already completed the procedure of acquisition. For the sake of argument, if it appears that the petitioner is in possession over the land, the same is an embargo upon the state. It is admitted upon the state, full stop. It is admitted that by virtue of issuance of notification under section 4 within bracket 1A, small 1A of the Act 2 of 1948, the land acquired by the state was vested to the state free from all encumbrances. Possession of the petitioner over the acquired land is a status of possession which has already been declared by the Honorable Division Bench, Honorable Constitution Bench of Honorable Supreme Court and Indore Development Authority, the Capital Court, Indore Development Authority, that the same possession cannot be taken into consideration. Under the above observation, I find no justification in the prayer of the petitioner to quash the LA proceeding. Under the above observation, the instant writ petition is disposed of.
One clarification subject to it. My lord has directed the KMDA to reconsider his application, but there will be one difficulty. My lord has recorded that at the time the land was acquired, at the rate.
At the rate when that land was acquired.
Because there is no scheme. Even if on humanitarian ground a plot is decided to be given to the petitioner, that should be at the as per the prevailing.
Not prevailing rate. Now you cannot. You have offered him. As you have offered him, let him approach. Let him approach you. I have directed to consider at the date of acquisition.
At the date of acquisition, whether that can be there. That part would be difficult for the authority to decide.
Yes,
because
otherwise, if I direct that today's rate, it would be harmful to the petitioner. Very harmful to the petitioner.
But if at all decides,
let you decide what you can do. Okay.
Because under the scheme
under the scheme, you have also not issued the letter under the scheme.
So when
as you have humanitarian ground offered the
letter, has recorded that.
Yes, humanitarian ground you have offered. So I allowed him to approach you properly. This
the book and the bunch, may I?
Yes. No, bunch you give it.
I'll give
a copy.
I'll give a copy. Because only one copy I have. We bunch আমি তখন দিয়েছিলাম
তারপর আস্তে আস্তে ডাকতে থাকো ডেকে ডেকে শেষ করছো
My lord, 30. I am for the response.
29 and 30, I am saying not today, my lord.
Yes, 29, 30, not today means not this week. It will appear Thursday. Okay. Very good. 31. Yes.
In terms of your lordship direction passed earlier, I have served notice even then. And my lord, I am paying only consideration order, my lord.
ওই যদি আগেরটা নিয়ে যাও
Yeah, I filed every service.
who is appearing for the state.
Mr. Warren.
Today you know the situation is otherwise.
I am paying only consideration order.
However, one should be appeared on behalf of the state. Ex parte order is not reservable, you know.
Yes.
And they have directed to file affidavit in opposition. They are not filing.
They have prayed for the extension of time. The issue has been decided in so many matters. Consideration order is also there.
Okay, give me affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Instead, despite service, none appears on behalf of the state. This is the under the stage of hearing.
Yes, ma'am.
Why hearing? Pleadings has not completed. Pleadings are not there.
Well, direction was passed in India 2020. First direction. There are extension was paid for.
Today I cannot dispose of your matter. You understand the situation. On regular dates I can dispose of this matter. On the other matter, the earlier matter, there are two persons are there. Okay, let the matter appear in the list under the same heading on 10th. Next week. 10th is the Thursday.
But 10 minor Wednesday.
10th is the Thursday.
You
10th of July.
only taking the and matter Thursday and Friday.
Thursday and Friday.
10, yes.
10 is the Thursday. Next. Next.
Be taken up in the next week. Petition পাবো দুটো This matter, my lord, was heard by my lord Justice Anindya Rai on extensively, my lord. I completed my submission. Thereafter, my lord, due to change of determination, my lord, again I have to start. All judgments I have, my lord, relied upon, those are submitted.
আপনি না আপনি এটা কালকে তো হয়েছিল কালকে এটা হেয়ারিং হয়েছিল না কালকে এটা শুনানি হলো না You argued this matter
Argued this matter before Justice Anuruddha Roy.
yesterday. You argued this matter.
No, no, that is another matter.
Another matter. I thought that this
No,
matter.
no, this matter, my lord.
Okay. And
That is another matter.
If possible on Friday.
he is the petition. He has to start first.
My lord, he is agreeable. No, he is agreeable.
When?
Next Friday,
Friday.
my lord, it is a matter of 2020, and my lord, on several occasions, matter was taken up for hearing. Last occasion, I completed
What
my.
is the matter?
Well, on the same points of law, that is, my lord, acquired under Act 2. Well, I have challenged the acquisition because here also Section 3 has not been served. No compensation has been paid. My lord, I am in position. And my lord, Indo development is not applicable in this case.
They are applicable.
Not applicable.
100% applicable.
Not applicable.
Let him. 100%.
Not applicable.
This is the point of law to be decided.
Yes.
Very good. Let the matter appear in the list on 11th of July 2025 under the same heading. 11th of July.
Maybe at 2 p.m. my lord, if your lordship can
Now,
fix it.
2 p.m. I have some fixed matter. I have already fixed the matters. Original side matter at 2 p.m.
Oh, Friday original set.
Develop.
শুক্রবার I am for the petitioner.
Who is for the state? Mr. Pantu Dev Roy.
পান্তু দেবরা সুব্রত গুহ বিশ্বাস
Pleadings complete.
affidavit is complete. They filed opposition. I filed affidavit in reply.
Today no one is there, so come Thursday. চলে আসবে Thursday তে normally. Normally Thursday not today.
Thursday.
Next.
I was representing the petitioner. My learned friend is representing Asansol Durgapur Development Authority.
ADDA.
হ্যাঁ দিতে হবে না যশোকে জাস্ট বলি হবে না মামলা my land has been taken milord it was acquired milord under milord the Land Acquisition Act milord for milord setting up a satellite township milord that was my learned friend's client's idea then milord they gave up the idea milord returned the land to the state government. In the interregnum milord Eastern Coalfields Limited had taken over the land through milord a memorandum of understanding executed with us.
Memorandum of understanding with the government.
With me.
With you.
With me. Milord, ECL took over the land. Milord excavated, coal mining activity started, but I was not compensated. Now, Milord, I have allegations against Adda, not Milord to that extent, that's true. But Milord, it was them, Milord, who initiated this acquisition. They were the requiring body. I have allegations against the state government. And I have principal grievances, Milord, against the Eastern Coalfields Limited. Today, Milord, I think, Milord, the state and the ECL, they are not there, and Milord, we have a resolution also. So kindly, Milord, indicate a date, and if, Milord, possible, Milord, a time, so that, Milord, because my land is no more there with me, I have not been compensated, and Milord, the scheme of ECL says that, Milord, there would be a twofold compensation. Milord, since I lose the land, Milord, I will be given a compensation, monetary compensation. And since I also lose my right to livelihood because I used to do agricultural activity or whatever, I will be given a job also.
Yes.
And none of this was given to me.
which is why, my lord, this petition. My lord, I was paid, my lord, there was a brick field being run. My lord, the brick field owner has been paid money. It was not me, my lord, who has been paid money. This is, my lord, the crux of the matter.
I think the ECL is yet to file their opposition.
My lord, if they choose not to file, that's their call.
Because
Who is appearing on behalf of ECL?
I am ECL Anchita was appearing initially. I don't know whether she is appearing.
It's for them, my lord, to decide whether they would file an opposition or not.
It is their option. Come on next Thursday then.
Very good. My lord. Would it be my lord's kind pleasure, my lord, to take it up at 2, subject to, of course, my lord's kind.
Who is, I have original side matters.
Very well, my lord.
Thursday and Friday both.
Very
I can fix 12:30 like that on only.
But may it be at 12:30 then, subject to my lord's convenience?
Let me see. Diary term. दस तारीख 11 तारीख देखो 10th of July and 11th of July 10th of July 2 PM আছে 12:30 তে কিছু আছে 10th of July 12:30
So grateful, dear lordship. Great. Great.
item number
It's my 36.
36 এটা লিখুন item number 12:30 please take down upon hearing the parties let the matter appear in the list on 10th of July 2025 specially fixed at 12:30 PM.
My lord, may there be also a direction upon me, my lord, to circulate notice.
Okay, petitioner to circulate notice upon all the parties regarding the gist of the order.
So grateful to your lordship.
Next.
Minute 37 minute, I appear for the respondent.
One is the petitioner. Not this week.
My lord.
Come for the petitioner. On the last occasion, state government filed an report, my lord, and I was directed to file exception to the report, if any, my lord. I am filing this today. One copy has already been served upon the.
Have you received?
I'm for the respondent number 4, my lord. Hold the development authority.
Who is the answering respondent? Who is the development authority?
No, state.
Both, my
State.
lord.
Challenge the acquisition proceeding.
Acquisition, not my lord. Petitioner is asking for a rehabilitation plot in lieu of his Bastu land has been taken. His 2 Bastu lands has been taken, but he has not been given any rehabilitation plot in lieu of that.
Okay.
And the reason behind this, there was a mandatory direction, my lord. May I kindly come to the writ petition. There is a mandatory order at page 38. Initially, petitioner filed one writ petition in 2006 asking for rehabilitation plot. 38, the paragraph, page 39, 4th paragraph, my lord. This is a mandatory direction. All the issues has been adjudicated, all their opposition has been taken account, my lord, in the previous writ petition. But they, in fact, after coming of this order, my lord, they have rejected my application for rehabilitation plot on the ground that I was residing in somewhere else. But this is cannot be a ground. I have 2 Bastu plots which are acquired, my lord. I should get at least one rehabilitation.
Have rejected your prayer?
Yes, my lord. That is at page 52. Rehabilitation Advisory Committee give a report at page 52, item number 17. at the time of acquisition, he was resident at Chiranjeevpur and he was not a resident at Hathiberia. So the petition is considered and rejected. His plot under Mauja Chiranjeevpur and one under Mauja Hathiberia, both were acquired. At least he should give one plot, one rehabilitation plot. If I applied for, I have applied for Hathiberia. If
Which
I
of the state?
Mr. Ramcharan Guchait, if I applied for Chiranjeevpur, their answer will be you are a resident of Hathiberia. When I am applying for Hathiberia, their answer is you are resident of Chiranjeevpur. But
What is the scheme about? Scheme is when you have acquired a vastu plot of land.
Yes, my
You
lord.
have to rehabilitate the
Yes, my lord.
land
And
loser.
there are
This is the
two, yes, my lord. There are two residential plot and petitioner was residing in both the place. I should be given at least one rehabilitation plot. I have applied for Hathiberia.
Hearing was given to you.
Yes, my lord.
Have you produced documents?
Yes, my lord. I have my eviction certificate, my CS record of right, my compensation award, everything is there. I have annexed all these documents. And then in their report, my lord, they have not filed any new document. All are pertaining to my writ petition. They have annexed the same.
Very good.
Nothing
Please take
new.
down exception to the report filed by the state on behalf of the petitioner is taken on account. Let the matter appear on 10th of July 2025 under the same heading. Petitioner is directed to inform the learned counsel for the state regarding the gist of the order. You just inform it.
Yes, my lord.
Item number 40.
Yes, ma'am. Well, in this matter, your lordship on the last occasion heard it, and your lordship has directed me to serve a notice upon the added respondent. That I have done already, my lord, so that they can file a report, comprehensive report. My lord will see the last order of the honorable court, my lord. That the added respondents was of the view that they will be filing a comprehensive.
This one 11 given level to file report.
Order. And the last day, my lord, your lordships heard, lordship directed me to serve a notice upon the added respondent. I have done that, my lord. Long back as on 11/6, because the matter was fixed on 26th of June.
Who is the learned counsel, Mr.?
My lord, Mr. Dhiraj Trivedi had been directed by the honorable court, appointed by the honorable court, to appear on behalf of the Employment Exchange Central Union of India. So, my lord, that has been done. He appeared also once. He appeared, and when the honorable court asked that whether the name has been forwarded, he said that yes, we have already done. The court wanted to see the honorable court wanted to see the paper.
That is the case of land losers.
Yes, land losers scheme, my lord. My lord, there is already there was an agreement that they have said that they will be giving one of the person of the concerned land loser service will be given. That was there, my lord, at page 16, I think, my lord. Your lordship may find it.
So have you served upon respondent number 11?
Yes, my lord, they are appearing. That is what I am saying, my lord. They have appeared. Mr. Dhiraj Trivedi had been appointed. Now, my lord, since he has been already granted the senior advocate gown, now, my lord, he is a senior advocate designated. So now, my lord, one of his junior is appearing in the matter who accepted this, and Mr. Trivedi, I had personally went and told him. He said that he will be filing a comprehensive report. Yes, they will do. So now, till date, no comprehensive report has been given to me. No copy has been served. Neither it has been filed. So, my lord, date was on 26th of June. That could not be taken up. So, if your lordship can fix a time and date, because the petitioner is suffering from long back, my lord, that is what I want.
Come on then 10th. Thursday,
10th, my lord.
10th. Next week,
Next week, 10th, lordship.
you inform that matter shall appear in the list. 10th.
Lordship. All parties, my lord. I will inform the.
You want any order?
Yes, my lord.
You want any order to serve notice? Yes, please take down.
I think that will be better.
Petitioner represented through learned counsel. Ms. Boisali Ghosha. None appears on behalf of the respondent.
Actually, there is, I think, today not to pass any adverse.
Yes.
That is the.
Considering the
I couldn't
situation,
say.
the matter be adjourned today. List the matter on 11th, on 10th of
10th of
July
July.
2025 under the same heading. The petitioner is directed to serve the notice regarding the gist of this order upon all the respondent concerned.
Yes, time be fixed. No, let them come. Then. Lordship.
My lord will recall, yesterday, your lordship, I have mentioned this matter. This is against, my lord, challenging a mutation order passed by, my lord, Bidhannagar Municipal Corporation. Now, my lord, there was a direction, if your lordship kindly takes the affidavit in service, my lord, dated 8th March 2024. My lord, I have made a letter to all the parties, my lord, all the respondents, stating that there was previous direction of your lordship regarding affidavit of service to be served upon us.
Yes.
In the 2023. And also another order that was also annexed. If your lordship kindly takes the service once, my lord. Now, my lord, accordingly, on the last occasion, there was a preemptory direction on the state respondent as well as the private respondents. None of them till date, my lord, have made any opposition to my writ petition. This is a 2022 matter, my lord. But this is the situation.
Who is appearing for the private respondent?
Mr. Gupta was appearing, my lord, Abhishek Gupta.
Okay.
They appeared on the last occasion, your lordship.
I understand. So, yes. The written in. अगर तारीख 10 তারিখে দুটো আপডেট করে দেব Okay. Count 11th. 11th at the top of the list of hearing. Okay. Please take down.
Well, in the meantime, I'll also communicate this order to all the parties.
Petitioner represented by through learned advocate, non-prosecution. It is contended by the learned counsel for the petitioner that in spite of service, no affidavit in opposition has been placed on record by the private respondent. Full stop. Considering the prevailing situation today, considering prevalent situation today, the matter be adjourned today. List the matter in the top of the list of hearing group 1. In the top of the list of hearing group 1 on 11th of July 2025. Full stop. The petitioner is directed to communicate the gist of the order to the respondents.
Deeply obliged. दीदी
There was a direction for filing of report which has been filed, Madam.
You filed it?
I have filed it. It is ready for hearing.
They have also placed on record the exception.
They have placed their exception.
Have you received the exception?
Madam, the exception to the report has. Right, exception to the report of the respondent number 427 has been.
You have received it?
Have received.
Okay. Respondent number 427 is represented by Mr. Banerjee. None appears on behalf of the petitioner. Let the matter be adjourned today. List the matter on 10th under the same heading.
My lord is keeping out your 10th.
10th.
My lord.